Resultantly, the writ appeal is allowed and the order dated 5/5/2026 passed in WP 68 of 2026 is interfered with and so aforesaid.
The matter was fixed on 28/5/2026, my lord, but Roshi was not able, that's why this matter could not be taken up. Roshi may pray this matter can be taken up Wednesday, man.
Which one?
My lord, the matter is already fixed on 28/5/2026 by Lordship. But since Lordship was not available, it could not be taken up. Lordship, may I pray this matter taken up Wednesday? The matter relates with the my lord, Twalpa,
That person
yes, ma'am.
whom we have granted some benefit.
My lord, absolutely.
Absolutely no. We'll take it up on Thursday.
Thursday, ma'am. Deeply appreciated.
May I please, Lordship? Lordship, affidavit on opposition filing item number 62. Lordship, the record, please.
Please, Your Lordship. I beg to mention item number 46, Lordship. And we have been engaged, newly engaged, Lordship, in place of earlier set of counsel, Lordship. And item 46, Lordship. And today we have filed local number, Lordship.
You have what? Petition?
A petition, Lordship.
Interim order?
There is no interim. It's admitted amount, Lordship.
What?
Admitted amount, Lordship.
Non-payment?
Yes, Lordship, it's a non-payment.
Why do you inquire for this?
There is a complication, Lordship, after 1 week, Lordship.
You are denying it.
No, Lordship, we have already filed our affidavit in opposition.
What do you say?
So we have disputed the claim.
You are disputing the claim.
Yes, Lordship.
Okay. Mr. So-and-so, the learned counsel appearing on behalf of the petitioner submits that some time may be granted, taking into account that he has been newly engaged in the matter. Considering the above list this matter on 27th of July, 2026.
May it please, Your Lordship. Lordship, with regard to item number 48 of today's daily list, Lordship, we have filed an affidavit in opposition in this case. May I kindly? Lordship.
Lordship, I beg to mention item number 59, my lord.
Item number?
59, my lord. My lord, we need to file impleadment petition, my lord. Impleading net fee as party, my lord.
We have filed an application.
Now, we'll file, my lord. Just 2 weeks time, my lord, my lord.
You have not filed.
Not filed, my lord.
You are going to file.
Going to file, my lord.
The counsel appearing on behalf of the petitioner submits that a petitioner is going to file an application for impleading of net fee.
Net fee, my lord.
Taking into account the above list this matter only upon such application is filed.
And
In answer to item number 29, the contempt matter, it is already complied, man. Amount has already been paid.
Who is the other side?
So I personally is there.
Huh?
For contempt, na.
You are for the contender.
I am for the petitioner. Petitioner.
You are for the petitioner. Item 29,
29, man.
judgment and order dated.
So I just,
I
inquired to the client, man.
No, do you mean to say that we are going to look into it? Because we have to say that the order has been complied with. What order? Come when you are prepared with it. We adjourn the matter.
Malo.
Counsel appearing on behalf of the petitioner being not prepared, 6 for an accommodation. List this matter on 24th of June, 2026.
May I please, Lordship? I beg to mention for listing of a admission matter.
When?
Wednesday.
Why? What matter?
It is about Van Dyke map.
Huh?
Van Dyke map. Van Dyke map of a land.
Van Dyke.
Yes.
That is not here, bench 5. We have no business with maps.
May it please, Your Lordship. With the consent of the other side, I beg to mention item number 43. May the matter will be fixed after 2 weeks.
What do you want?
The matter may be fixed after 2 weeks, Your Lordship.
Counsel for the petitioner,
Respondent number 4.
you are
We are on the behalf of petitioner.
urgency,
They have taken number of dates, several dates for
then no,
filing.
they are opposing it. We'll have when the matter is.
Your Lordship, we are going to file affidavit in opposition.
That is not there.
3-4 days
We
already
don't allow
passed.
these type of things. We will give you with a cost of 50,000, pay to them. 50,000? You pay 50,000, take, how many adjournments you want? 50,000? No, then no, not done. Next.
Publishing.
Also joint prayer in respect to item number 64, Lordship. The
60.
matter has 64. The matter has been settled, Lordship, before the mediator. Last 2 occasions due to paucity of time, this Lordship.
For that matter, what has happened?
Lordship, mediator, matter has been settled, Lordship.
Settled.
Yes.
I am not in touch with the union, but the report says well, they have settled the matter.
With the mediator.
Mediator's report is there, agreement is there. And we close book.
They were earlier reinstated in terms with the dishonorable court's interim order. Only issue.
Their news part was
that
there.
was- And that has been settled.
Heard Mr. K. will tell the learned counsel appearing on behalf of the petitioner. Mr. K. M. Halloy appear. Mr.
I'm for
K.
the
M.
workman.
Halloy appears on behalf of
What?
the respondent numbers 1 to
32.
30,
32. The workmen, all the workmen.
32. Gustav. The instant with petition has been listed before this court. Pursuant to a mediation, pursuant to the report submitted by the mediator. The report is at where's the report?
Memorandum of settlement is there. On record.
From the report of the mediator, it is seen that a memorandum of settlement has been reached by and between the petitioner and the
Union, Silpa Shramik Union.
Silpa Shramik Union representing the private respondents. Pusto. The memorandum of settlement so submitted along with the report is accepted by this court. And the parties herein shall be regulated on the basis of the memorandum of settlement dated 7/5/2026. The contents of the said memorandum of settlement shall be deemed as an order passed by this court. And the compliance thereof be carried out as per the terms of the said memorandum of settlement. With above the instant petition stands disposed.
Much.
The records of the learned tribunal, labor court,
Tribunal.
industrial tribunal,
Industrial.
be returned by the registry forthwith.
Much.
Item number 42, Lordship, on the last occasion on 24/4/2026.
Huh?
Your Lordship has directed a VC of respondent number 3 in item number 42, Lordship.
42, yes. What do you want?
And VC was directed lordship to respondent number 4, that is the principal of Tinkhang College, lordship.
Yes.
So yeah, it was written there that at 10:30 it should be mentioned, lordship.
We'll take it up when the matter is.
But lordship, if it's taken at 11 PM, lordship, then it's okay, lordship.
Why
11
PM?
AM, lordship, because the VC link is not ready yet, lordship. The VC link we have not got till now, lordship.
Oh, is it the same state of affairs? Now we are being told that all matters are
We have
normally
applied
to be
that.
taken by BC and
After-
only
after-
otherwise it is to be taken physically, and the High Court has not been able to provide BCs. You are paying for the principal. Take it up at 2 o'clock, after my judgments after 2.
Yes, lordship.
Make the dimensions. Lordship, I beg to mention item number 20, Lordship. In this case, this honorable court directed me to produce the NIT, Lordship. We have submitted RTI application, but till then not received, Lordship. After a week, Lordship. The matter it relates to fishery, Lordship. Let the NIT people,
Let the matter be taken up when the matter is there.
Lordship.
Already cancelled, Lordship. We have already
I
cancelled.
know, therefore I say, when the matter is taken up in Syria team, we'll take it up.
Lordship.
More.
Motion.
Yes, what is this?
Well, in item 18 and 19, I have received the instructions, they have already moved the FOC, once the FOC is received, the amount will be paid. There is some time taken, because the petitioner, there is he did not have the GST. GST number he did not have. Therefore, some time taken to process. Now it is processed and the proposal has been sent. The FOC is awaited.
How much time
Lordship may keep it on the reopening
after vacation?
after the election.
Mr. Deenat, the learned senior government advocate who appears on behalf of the respondent, submits that he has received the instructions pursuant to the order passed by this court on 25/2026. He submitted that the due applications, the file have been processed for the issuance of the FOC. And immediately upon receipt of the same, the payment would be made to the petitioner. Taking into account the said instructions so placed before this court, which is kept on record and marked with the letter X, this court fixes this matter again on 27/2026, 207/2026. In the meantime, the respondent hearing shall take few steps for disbursing the amount to the petitioner.
Instead of 27, can it be 29?
Huh?
Instead of 27, 29.
20.
Or 1. Well,
Your presence not required. You get your money.
yes, this is in respect of the second case. Second also. There are two cases, I have received two instructions, 18 and 19. All of 19 also. 19 also.
20. 27/2000. 19 also same.
19 also.
Same. Yes, what is this?
The matter
For
relates
the purpose
to
of adjudication of the issue, more particularly taking into account the stand taken by the petitioner in the review, giving the without the notice that cannot be brought. Okay, now tell me one thing, what are you asking for here?
remission of his lordship.
Shall direct to reassess and refix the annual revenue of so and so. Shall not be directed to consider and decide representation. Shall not be directed to grant remission. Now you have cancelled that.
Yes.
That is okay, but there will be a question of certain amounts to be paid by him.
No, Lordship, that part, they cannot claim because of the clause 23 in their NI. Because that has been decided by the division bench also. That,
How do you know about that clause 23 in the NIT, which he is not being able?
no, in the agreement, I know, Lordship, that I know.
So
I
you must be having a copy of the NIT.
No, I'm not having. I
So
know
then
that
how
there
do
is,
we- how
there
do
is
we
always a
get-
copy.
No, Mr. Sharma, don't make this type of submissions. First, he's not being able to get a copy of the NIT. He's filed an RTI, he has not been. And now, on one hand, he's saying this, he's making that submission. And on the other hand, you are relying on clause 23 of the NIT.
That I can produce the documents, Lordship, the record.
Okay, you produce the NIT, matter over.
Yes, Lordship, when Lordship.
List this back. So Mr. P. Sharma, the learned counsel, Mr. P. Bodler, the learned counsel appearing on behalf of the petitioner submitted that he have not been able to procure the notice inviting tender, though an application has been filed under the Right to Information Act 2005. However, it is relevant to observe the submission of Mr. P. Sharma, the learned standing counsel of the fishery,
No,
AFDC, department, AFDC, wherein he submits that in the meantime, the said settlement
Yes.
in favor of the petitioner have been cancelled. So this court put a specific question to Mr. P. Sharma as to whether the petitioner's claim made in the writ petition become infructuous in that view of the matter. Mr. P. Sharma submits that in view of clause 23 of the notice inviting tender, the petitioner cannot make these claims.
Lordship, may I be wrong in that clause, in the clauses of the NI.
Submits that in view of the clauses of the NIT, the petitioner cannot make such claims.
Yes.
Apparently, in view of the said submission, the respondents are in possession of the notice inviting tender. Considering the above, list this matter again on 15th of June, 15th of June 2026, on which date the records of the present proceeding, of the settlement proceedings for the petitioner be produced before this.
File your.
Oblige.
What is this?
Last occasion, your lordship, I was, in the last occasion, I was asked to take instruction regarding the informed order, whether it is in force or not, your lordship.
What order?
Yes, 53, your lordship.
What are you challenging?
Yes, 53, your lordship.
Set aside and wants to impugn moratorium to the commissioner secretary so and so. What is this moratorium business?
One issue.
What are you challenging?
Herein, your lordship, the institute of the petitioner have.
You are challenging Annexure 15.
Yes, 53, your lordship.
The government of Assam in the so and so hereby directs that no letter of intent of letter permission shall be granted for establishment of any pharmacy institute during the current financial year, except in respect of Pune. How is this relevant?
In the last occasion, your lordship, I was.
The financial year is already over, Mr. Counsel. This document is of 2025. Financial year ends on 31st of December March 2026. Your petition has become infructuous.
But LOP has
That
not.
is a different thing. But your basic document, this executive order is only for that financial year. So what remains? For not granting it, it's another aspect to the matter. But this executive order has become infructuous. Who is appearing for the medical education department?
Herein, your lordship. Herein, your lordship. We
Absolutely
have,
no. No, Mr. Counsel.
we have already submitted application.
Understood. That is a different aspect.
That is also the-
Non-consideration is for difference, but this is not your ear. You are asking for ear. The issue of letter of hearing in favor of the Central College of Pharmacy under so and so for starting diploma course under so and so.
But another prayer is there, your lordship, for
So, the first prayer has become infructuous.
and accordingly.
Issue notice making it returnable on 27/2026 20. None appears on behalf of the respondent numbers 1, 2, 3, 4. Though there are standing councils appointed by the standing councils of the health department who appears on behalf of the said respondents. Under such circumstances, this court directs the petitioner to serve copies, extra copies of the petition upon Mr. B. Gogoi, the standing counsel of the Health and Family Welfare Department. As regards the respondent number 5, the petitioner is directed to take steps by way of speed post within 3 days. At the outset, Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, submits that the relief number capital A no longer survives, taking into account that the executive order dated 2012-2025 was only limited to the financial year 2025-26. The learned counsel, however, submitted that the petitioner had duly submitted the necessary applications for the purpose of issuance of the letter of permission in favor of the petitioner, in favor of the Central College of Pharmacy under JRG Educational Trust Walpara for starting diploma in pharmacy (D Farm) course. However, the said application have not been considered. It is therefore the submission of Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, that appropriate redirection and order are required to be passed to the concerned respondent authorities for due consideration. The respondent herein, more particularly the respondent numbers 1 to 4, are directed to apprise this court as to why the petitioner's application seeking the letter of permission have not yet been considered. The said aspect be brought on record by filing the affidavit.
Any date, your lordship, you could-
What?
I'm saying, your lordship, if your lordship will fix this matter. For fixing this matter,
Well,
any date, your lordship.
I fixed it.
Okay.
But this matter may kindly be passed over the time being.
Why?
My senior as the pay leading me in this case, he is in on legs on number 1.
Why are you making all these people a party?
Lordship, it pertains to the non-release of the salary of the petition. Non-release of the salary of the petitioner since last July 25.
Non-release of
It's the salary of the petition.
labor court. Why?
So what has happened, Lordship? The petitioner was posted as a Minister of the Industrial Tribunal of Dibrugarh. On 26/25, there was a transfer order transferring the petitioner from Dibrugarh to as Registered Labour Court Gauhati, and vice versa, the Registered Labour Court of Gauhati was transferred to Industrial Tribunal Dibrugarh. That order was challenged, Your Lordship. In the meantime, on 7/7/25, the petitioner joined here because as there was no stay in the writ proceedings pending before this court, the petitioner joined as registrar of the labor court. Lordship, the transfer order was then set aside on 2/12/25. Then we preferred the petitioner preferred a writ appeal. In the writ appeal, Lordship, there was an order that both, if possible, both the parties may be accommodated. But there was no stay in the order of the learned single judge. Now the main contest starts from here. A fresh order of transfer was passed on 11/3/26, Lordship. Then this order is in page 44.
Then
Pursuant to that order, Lordship, the petitioner handed over the charge as a registrar of the Industrial Tribunal on 14/3/26 and took over charge as the registrar of the Labor Court Gauhati on 15/3. But your Lordship, since the first transfer order, since July 25, he was not being paid to salary because the case was pending in this honorable court. The writ appeal was pending. He was not paid salary. Now, what happens, your Lordship, when a transfer is effected, the name.
yes, Mr. Das, what is this?
Well, this is
Whatever may be, you are the whoever is transferring from here to there or whatever, it was still in job.
No, that's true, Miller. Absolutely correct. There was
Then
some
why is he
confusion.
not being paid?
If I have understood correctly, Miller, there was some confusion. He made a own request transfer prior. That was executed by the government. Transfer order issued permitting him to from Dibrugarh to Gauhati. That order was challenged by before this honorable court. This honorable court set aside and quashed the transfer order. Thereafter, in a complete contemptuous manner, this page 44 order was passed by the Principal Secretary Government of Assam Labor Welfare Department. After setting aside of the transfer order, how can the petitioner be again posted at Gauhati? It is absolutely contemptuous, Miller. And this order was later on challenged before this honorable court by filing a writ petition. Unfortunately, the petitioner, he did not file a contempt. The previous two
This order is under challenge, Lordship.
So after this order is challenged in a subsequent writ petition now, if I
What is the name of the petition?
Vidyut Kumar Das, this order is
Now there
on the
is
face
another petition 1507
Yes.
2026.
So the lady, the private respondent, she again challenged this order, saying that this is on the face of it, it's contemptuous. And in violation of the previous order.
How this matter came up before another bench?
Not perhaps because of the labor court issue and
No, Lordship, it seems that
Then obviously this court would not have the jurisdiction today.
Lordship, the Registrar General is also a party in this.
this matter should have been come before your
Come
lordship.
up before me.
The initial transfer matter also
Yeah.
should have been before your lordship. Because other industrial tribunal matters, they are regularly coming to your lordship.
This is before me. Anyway.
So finally, the situation is like the presiding officer is absolutely confused. The presiding officer, as I have understood, and in the subsequent writ petition, Millard, there was no stay of this contemptuous order. This should have been stayed at the prima facie on the face of it.
And what
There
has
was an
happened to-
interim direction.
What has happened to 1507?
It is still pending, Lordship.
There was an interim direction.
There
not
was
to
no
post
stay on the
action.
order of the transfer, the fresh order of transfer in the month of March.
But this honorable
Now,
passed an
what is-
order not to take any coercive action.
Now, what has happened, Lordship, the petitioner has given a representation on 28/4. So your Lordship will kindly find the representation annexure 10, page 59. To release his salary, Lordship,
What has happened?
If
to the honorable presiding officer,
Then no coercive action shall be taken against the writ petitioner. Writ petitioner is only court.
yes. No coercive against the writ petitioner, but the learned presiding officer, for reasons known to him, he is understanding it if he releases the salary or transfers the name of the petitioner from the portal from Dibrugarh to Gauhati, that will mean as a coercive action against colleague. This man is without salary for the last 11 months, Lord.
other way around, if I have understood correctly, if the Milord, they are
Wait,
saying
wait,
that
wait,
FIN Assam portal.
First, let us understand. First, Where is this order? This order is passed in the interest of public service. Vidyut Kumar Das, register is hereby transferred and posted as vehicle Liverpool, Gauhati. Then in the interest of public service, so and so is hereby transferred as they are Dibrugarh. Okay, so this has happened.
Yes.
It's a
challenge.
So these is being a transfer there. These were challenged.
Page 27
Page 27
is the order and
Now, this order was challenged. So you have been brought from Dibrugarh to Gauhati
Yes, Lordship.
and she was brought to from Gauhati to
To
Dibrugarh.
Dibrugarh.
and it was on request.
Okay, whatever may be, then
Yes.
this order was challenged and the writ petition was disposed of.
Page 39 is the operative portion.
Accordingly, they allowed in, so it's transferred, it is set aside.
Yes.
Then
A writ appeal was filed
by you.
by the petitioner.
By us,
So,
the petition.
As because
Your Honor, in the writ
petition
appeal-
is let the appeal be passed, the order be passed, no the pendency be. A fresh order of transfer is now required to be passed accommodating both the appellants and so and so. So the division bench says that pass a fresh order.
Yes,
because after setting aside, there has to be some order.
So then what they do,
they passed the fresh order on 11/3/26.
again putting you in Dibrugarh.
Yes. No, me from Dibrugarh to Guwahati.
Only कुछ register Guwahati है को, labor code Guwahati is transferred from here to Dibrugarh.
The same.
You have been, so it is the same order.
Same.
Yes,
So this is in your favor.
yes,
So till this, it is okay for you.
yes.
Page 44 is okay. Then what happens? Then police
Then-
against challenges this.
Again
That,
challenge.
okay, I have challenged this, now what has happened?
Now, that
Now,
order,
considering the issue involved in here, so and so, so and the matter. be
Page
posted
54
up
if
to
you're-
1 week instructions. Now. Then,
Lordship will
then
kindly,
this order comes at page
54,
1/4/2026.
yes.
Where there is a direction, no coercive action shall be taken against the petitioner.
But that order comes on the submission by the learned counsel of the respondent number 10. Your Lordship will kindly see para 4 of that order, 1/4/26, page
Submit
55.
that she has not handed over the charges on date. He further submits that a claim of the private respondent regarding handing over charge is not correct. And it is submitted from.
He had already handed over.
So you have not handed over the
I
charge.
had handed over charge, your
This
Lordship.
was the submission made.
There was a submission made on
So and
basis of
therefore the court has passed no coercive action.
no coercive against.
Okay, so no coercive action, now you are not getting your salary.
Yes, Lordship.
So the only way out is tag this matter with that. And then finish it off.
Lordship, we have an interim prayer also, just to transfer the name from the Assam Fin portal. At least I can get my current salary from the month of March.
But I think there is some problem. Why I'm saying
No,
so.
no, the problem is not-
Yes.
apart from that, you see, no coercive action when this order is being passed. That will also be understood that this polycoach cannot be removed from there.
But I have already handed over charge there and joined.
Understood, all these things are understood, but with this order remaining, there is this problem.
But Lordship also has to
The
see
court should
without,
have stayed this order, that's a different
that
thing.
would have been a different.
The court should have, when it has been set aside and again doing the same thing, the court should have set aside this order, whatever may be, but I think we need to issue notice. And you take by dusty and before vacation, we complete of this matter. That is the only way out.
Yes, ma'am.
Because issue notice, making it returnable on 25/6/2026. Labor. Mr. K. Gogoi appears on behalf of the respondent number 1 and 2. 1, 2, and 3. Finance, no finance. Mr. So-and-so appears on behalf of respondent number 5, 6, 7, 8. And why are you making the presiding officer by name?
Unnecessary.
No, Lordship,
Why are you making him by name?
Lordship, there is a reason for making him.
Are you alleging malafiding
Yes,
against me?
Lordship.
Why?
Lordship, what has happened? We have given a letter to him.
I'm not issuing notice. 5, 6, 7, 8.
10 by Dusty.
Taking into account that the Finance Department of the Government of Assam has a standing counsel but have chosen not to appear, this court directs the petitioner, counsel for the petitioner, to serve a copy of the writ petition to Mr. B. Gogoi, learned standing counsel of the Finance Department. Extra copies of the writ petitions be served upon the respective counsels. This court is not inclined to issue notice upon the respondent number 9. Insofar as the respondent number 10, steps be taken by way of speed post by tomorrow. In addition to that, the petitioner is directed to take steps upon the respondent number 10 by way of dusty routed to the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the service upon the respondent number 10 by way of dusty is completed on or before 17th of June 2026. The case of the petitioner herein is that the petitioner have been appointed as the registrar of the Industrial Tribunal. Dibrugarh. There was a transfer of the petitioner from the Industrial Tribunal Dibrugarh to Labour Court Gauhati, and the respondent number 10 from was also transferred from the Industrial Tribunal Dibrugarh to the Industrial Tribunal.
Respondent number 10 from Gauhati to Dibrugarh, Labour Court Gauhati to Industrial Tribunal Dibrugarh.
You are from Industrial Tribunal Dibrugarh to Labour Court Gauhati.
10 from Gauhati.
On the other hand, the respondent number 10 was transferred from Industrial Tribunal Dibrugarh from Labour Court Gauhati to Industrial Tribunal Dibrugarh. This transfer order was made by notification dated 26/2025. The said notification was challenged by the respondent number 10 by filing a writ petition which was registered and numbered as WPC number 3585/2025. The learned coordinate bench of this court by an order dated 2/12/2025 has set aside the said notification dated 26/2025. The petitioner thereupon preferred an appeal before the learned division bench of this court, which was registered and numbered as WA 409/2025. The learned division bench of this court, though admitted the appeal has been admitted, na?
It has been disposed of
Finally
also
disposed
as
of by the learned division bench of this court by an order dated 18/12/2025. Observe that the writ appeal shall be heard on merits on the next date. However, it was also observed that in the meantime, there would be a requirement of passing a fresh order of transfer, thereby accommodating both the petitioner and the respondent number 10 hearing. In pursuance thereto, another notification was issued on 11/3/2026, whereby the petitioner was again posted in
Gauhati Lodge.
as Registered Labour Court Gauhati, whereas the respondent number 10 was posted as Registered Industrial Tribunal Dibrugarh. This notification dated 11/3/2026 have been put to challenge by the respondent number 10 by filing another writ petition being WPC number 1507/2026. The record reveals that by an order dated 1/4/2026, on a categorical submission made by the counsel appearing on behalf of the respondent number 10 in the said proceedings, to the effect that the petitioner herein had not handed over the charge of the Industrial Tribunal Dibrugarh, of the post of Register Industrial Tribunal Dibrugarh, passed an order that no course of action shall be taken against the petitioner therein, who is the petition respondent number 10 herein. The grievance of the petitioner herein is in the same process of issuance of various notifications whereby the petitioner has been transferred out of Dibrugarh to Gauhati, and the respondent number 10 being transferred from Gauhati to Dibrugarh. The petitioner have not received salary, been disbursed any salary for the last
11 months. 11 months.
11 months. And it is under such circumstances the petitioner had approached. The respondents herein, more particularly, the respondent numbers 1, 2, and 3. 1 and 2 shall apprise this court as to why the salary of the petitioner have not yet been released. The respondent number 4 shall also apprise this court. 1, 2, and 4 are directed to apprise this court as to why the salary of the petitioner have not been released. First, this court is also of the opinion that on account of the order passed on 1/4/2026 in WPC number 1507/2026, the situation in the present case had occurred. Accordingly, this court directs the registry to list WPC number 1507/2026 along with the present writ petition on the next date.
Deeply.
And I'm too happy. Yes.
This is that beyond appointments, my lord. There's been already one round of litigation which has already happened. And your lordship says, in fact, that order at page 85, in terms of that appointment that happened in regards to the promotion as well as recruitment of peons. So the first promotion was set aside. This is regarding to the appointment.
Oh, those 5.
Yes, my lord. Those
He's
5.
appealing for 2.
2.
Huh?
In terms of your lordship's.
4 and 5.
Yes.
And Mr. D.
One
Das
and
is
2.
coming for the other one. Then?
In all fairness, I think he must have decided not because it is correct, also because he'll have a problem if that is taken.
So 1, 2, and 3 is not coming, Mr. Mohammed?
1 and 2. We are 1 and 2, my lord.
You are
Vidisha
1
and
and 2.
yes, ma'am. 3 and 4 is
Vidisha Talukdar and Sandan Datta.
yes, ma'am.
And 3 and 4, they are not coming.
They have not come.
They've left you.
Now, in terms of your last order, my lord, that was passed at 81 in the previous round of litigation, my lord. At page 83.
In the earlier affidavit they filed,
Yes, my lord.
they have categorically mentioned that there were certain mistakes.
Yes, there were certain anomalies in regards to
Kindly
marks.
keep them to page
Minus
67.
64.
67.
After thorough scrutiny of the complaint of so-and-so, it was found that there were substance in the allegation, so-and-so scoring so-and-so ought to have been selected and you are by virtue of so-and-so. Again, complaint so-and-so, scoring so-and-so and so-and-so. Therefore, there were gross and evil in preparing this and there. And there was sufficient reasons to derive conclusion of cancelling the select list as well as the appointment of the dated so-and-so. Should notice making it returnable on 23rd of July 2026. Mr. So-and-so accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the petition be served by tomorrow. The petitioners herein are aggrieved by the order dated
The cancellation is 25/6/2025.
page 48.
Page 40.
By the cancellation of the appointment order dated 10/4/2025. By the order dated 26/6/2025, whereby the appointments of the petitioner dated 10/4/2025
Yes, ma'am.
were cancelled. It is relevant to take note of that this is the second round of litigation. And on account of conflict, on account of the stand so taken by the respondents in the earlier rounds of litigation being WPC number 4043 of the 2025, the petitioner had to withdraw the writ petition seeking liberty to approach this court. The respondents herein are directed to bring on record their stand by filing the affidavits on or before the next date. On or before, no, I fix it on 23rd, no?
20.
On or before. 15th of July 2026. It is observed that taking into account that this is the second round of litigation, if the affidavit is not being filed by this respondents, this court shall dispose of the writ petition, taking into account that the stand of the respondents are already available on records.
The apprehension is that I hope they don't go with the new advertisement. Don't worry. That could be the only apprehension I have. Rest I leave it to you.
Bhutan, don't worry.
Okay, I'll leave it to
When
your
this court
lordship.
takes up with matter, nobody does.
I leave it to you. Extremely good.
Be clear.
If your lordship recalls, madam, this is challenging the selection process for appointment of senior administrative assistant in Labour Court Gauhati. Your lordship will find the advertisement at page 26.
Oh, yes.
Now,
What
my
have you done? This is the second round.
Yes, my lord.
Why the High Court doesn't have any notice? This system appears to be apparently wrong.
After your lordship's last order in the.
That is there, apart from that. First of all, it has to be done under the recruitment. Secondly, it seems that he has adopted why the CGM establishment rules have been taken for the purpose of head assistant. Head assistant, how do you appoint in CGM establishment? You call for everybody.
Yes.
1987 rules. But on the other hand, the district administration rules, establishment rules is different.
Yes.
Where it is intra,
Intra.
it is intra the establishment. Whereas this CGM is inter
Your lordship's
establishment.
held on one of the matter. This one.
Yeah. But why he has adopted the senior?
Apart from that, there is anomaly in the grade pay also. After the corrigendum, they say the particular grade pay is required. But this private respondent, he doesn't have that grade pay, which is apparent or prima facie reveals from the repetition.
That is
May I just
principle.
frame your person, please to issue notice. And let me get the clarification from
I'll
the,
issue notice because this seems to be not in the manner.
something is not conforming.
But I have
And
made
more
a-
particularly, in view of your own admission, means on admission of the high court out there, that insofar as all other posts except the race
Centralized,
falls within the ambit of 235.
centralized recruitment is done.
It is under the centralized recruitment. So under
How this can be done individually, that's true.
issue notice. Issue notice, making it returnable on 30/7/2026. It's the AGO accepts notice on behalf of the respondent number 1 and 2.
P4, 6 and
As
7.
regards respondent number 3, 4, and 6 and 7. Mr. So-and-so accepts notice. Extra copies of the petition which served upon them by tomorrow.
Wait.
As regards the respondent number 5, steps be taken by way of speed post. So in addition to that, the petitioner is also directed to effect service upon the respondent number 5 by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. The petitioner should ensure that the service upon the respondent number 5 is effected on or before 24th of June 2026. The petitioner herein are aggrieved by the selection of the respondent number 5.
Page 34.
Where is the appointment order?
Page 34.
Selection and appointment of the respondent number 5. Has he been appointed? No.
He has not joined, madam. As of date.
Appointment order?
No, madam, there's not. Because, madam, off the record, what I could gather is that he didn't take the proper permission for appearing in the selection process.
So therefore, he has not done. No. The notification dated 6/5/2026, whereby the respondent number 5 was appointed, was selected for the post of UDA bracket senior administrative assistant in the office of the Labour Court, Gauhati. It is the case of the petitioner that till date, the respondent number 5 have not been issued the appointment letter. It is the case of the petitioners allege in the instant of proceedings that the selection of the respondent number 5 was divorced the what rules?
Madam, my principal matter, case is that as per the notification of the judicial department, he doesn't fall, he is a system assistant. So he doesn't fall under the advertisement, madam, as per the curriculum.
It is the specific case of the petitioner that the respondent number 5 is a system assistant working in the establishment of.
Madam, he is currently posted, madam, at Sessions Court, madam.
You don't know.
district and session judge, Kamrup Metro at that establishment.
It's working as an system assistant in the establishment of the district.
May not, I'm not sure, may not record.
Your petition, then we should dismiss again on this.
It's not
No, no, no.
reflected anywhere in the entire selection process.
The council appearing on behalf of petitioner is not ready.
No, that's.
Then why we should, why you are saying that he's a system assistant? Mr. Bhardwaj? Tell me,
This is a district and session judge Kamrup.
no, why you are saying that he's a system assistant? What is your basis?
But I was instructed, although the establishment was not informed.
So we don't stay there. Because you are not aware.
Just give me a minute, I'll get
No,
it.
you are not ready. The petitioner have essayed the appointment, the notification dated 6/5/2026 on the ground that as per the advertisement dated 4/11/2025 issued by the Labour Code, Gauhati, the requirement, the requisite qualification requirement is serving as junior administrative assistant, having not less than 5 years of continuous service as on 1/1/2025 in any district judiciary of Assam. It is the case of the petitioner that the respondent number 5 do not have the said requisite qualification. This court inquired upon the learned counsel appearing on behalf of the petitioner as to on what basis the petitioners make such allegation. The learned counsel could not
It's written.
place before the court.
That para 10, man. It's there, man. Para 10.
Page 10.
Oh, sorry, page 10, second para.
Where?
As such, the respondent number 5 being a system assistant presently working at Kamrup Metro District Division.
Huh?
Page 10, my lord. Page 10, second para. First name.
Submits that the respondent number 5 belongs to the cadre of system assistants under the Gauhati High Court and District Court, E-Court, Recruitment and Promotion Service Rules 2015, which is not equivalent to the post of junior administrative assistant. However, the counsel appearing on behalf of the petitioner could not say as to where the respondent number 5 is working. Considering the above, this court is not inclined to pass any interim order at this stage.
My lord, just now I've been informed, my lord, he's in the Kamrup Metro.
Sorry.
District and session just establishment, my lord, Kamrup.
So you should be more ready.
My lord. Kind enough, man. But I'm paying for it, my lord. Since he has not joined, my lord. Some protection since he has.
Why should it? Did we say that if he joins, he'll be subject to the outcome of the police?
I'll be satisfied with it. I'll be satisfied with it.
No, I'm not satisfied.
But till date, he has not joined, and there are
So if
clearly
you
certain
let-
anomalies which my other friend will find out. my
In
lord.
the meantime, Mr. Das, you take it up with this. You are not ready. The
Madam-
council is not ready. We can't allow this type of.
Well, once more,
And I would have understood this matter coming up for the first time. First time I asked you to withdraw. With liberty, I showed you which are the places where you need to make the allegations. You will have a good case. Then also, you are not ready.
my lord, it has been done so at page 10, my lord has stated so. My
Page 10 what?
lord, Kamrup Metro Judiciary, my lord.
You have not mentioned where he is working.
So he's in the district and session judge establishment.
Where?
Kamrup Metro.
So we'll see when you. Council appealing on. It does not belong to the, is not equivalent to the post of junior administrative assistant. taking into account that the said aspect has to be decided. It is the opinion of the court that it is the opinion of this court that the petitioner's hearing would be entitled to a limited interim order to the effect that any appointment letter issued to the respondent number 5 in the meantime shall be subject to the outcome of the petition.
And your question. Sorry.
Deeply.
May it please your lordship.
What is this?
Your lordship, the present petitioner before your lordship was working as a process server under the respondent authority, your lordship. And he served a summon, your lordship, to the defendant in respect of a title suit in the year of 2010, your lordship, pursuant to which an ex parte decree was passed against the defendant, your lordship. And after a lapse of 14 years, your lordship.
Petitioner served summons in title suit and as per directions and submitted an ex parte decree was passed on one and progression was filed the complaint alleging forgery of signature and non-service of summons. The said complaint was a bail letter not supported in violation of the.
So our prayer in this petition is very simple, your lordship. We have filed a statutory appeal before the respondent number 3 on 31/2026.
Before respondent number
3, your lordship.
But
now it's already 4 months, your lordship. Till we have received no response from their end, your lordship. So we have a prayer to dispose our first appeal as soon as possible, your lordship. This is our limited prayer, your lordship. Because as per the rule 24, your lordship, if a statutory appeal filed, it has to be disposed of within a period of 3
wrong with
months.
your respondent, this respondent secretary judicial. Why is he not in a position?
Prayer, page 9 in the prayer, your
Prayer for the secretary judicial. Why does it take such a long time? Does it take 4 months? Or was he too much busy with the elections? Something to the effect. It can't remain pending. No. The appeals can't remain pending.
And your lordship, we have.
Not then we say that you are not competent enough. Are you not competent?
No, my lord.
Are you competent or not?
Yes, my lord.
Yes. Then within 3 weeks, we need the decision. Okay. And place it before the court. We keep this matter pending. Then only things will, otherwise this secretary judicial, they don't work. Issue notice making it return. We have it before vacation, the order. On 25th of June, 2026. Mr. So-and-so appears on behalf of the respondent numbers 1 and 3. Mr. So-and-so appears on behalf of respondent number 2 and 4. And 5. Extra copies of the petition be served upon the learned counsels by tomorrow.
Lordship.
The instant petition has been filed by the petitioner on a very limited prayer, seeking a direction upon the respondent number 3 for disposing of the statutory first appeal dated 31/2026, preferred under Rule 13 of the Assam Services (Discipline and Appeal Rules) 1964. We have it after vacation. Let it be on 23rd of July. The learned counsel appearing on behalf of the petitioner submits that the petitioner who was working as a what?
Process server, Your Lordship.
Was a process server. His services were terminated by an order dated 10/12/2025. The learned counsel appearing on behalf of the petitioner submits that the petitioner is the sole bread earner of the family. And these very aspects were not taken into consideration while imposing the penalty in respect to an alleged violation which took place 16 years from today. Indian Council further submitted that an appeal thereagainst was filed on 30/1/2026. But no steps in that regard have been taken by the respondent number 3 for disposal. Considering the above, this court in the interim directs the respondent number 3 to take effective steps for disposal of the appeal so filed by the petitioner and place the decision before this court on the next date so fixed.
Compulsory.
Compulsory. Punishment will be clear. Punishment of compulsory.
Applies, Lordship.
What is this? My lord, we are before, my lord. My lord, may at first come to page 42, my lord. This is, I was a subcontractor. Permission was granted by the IOC to work as a subcontractor. I successfully worked for 3 years. Then satisfied with my work, they extended my work by another 2 years. So I completed 5 years of unblemished contract service. But suddenly, after granting me the final completion certificate, the contract is over. Everything has been discharged. Now on 28/10/2020, this is page 62, Annexure K.
Page
62, my lord, Annexure K.
Yeah.
They write this letter to my main contractor. They have, in the bottom part, they have cancelled the final completion certificate. They have, and they have cancelled my whole credentials, my lord. Please note that the documents are invalid and stands cancelled. You are hereby directed not to use any form of the attached
So you are
document.
challenging this document.
My lord.
You notice returnable on 27th of July, 27th of July, 2026. Mr. S.S. Roy accepts notice on behalf of the respondent number 1. As regards the extra copies of the petition be served upon him by tomorrow. As regards the respondent number 2, 3, 4, and 5. Steps be taken by the petitioner by way of speed post. In addition to that, by tomorrow, by within 3 days. In addition to that, the petitioner is also granted liberty to take steps upon the respondent number 2, 3, and 4 by way of the steel, routed to the registry of the court, and file an affidavit of service on or before the next date. The service of the respondent number 2, 3, and 4, if taken by way of the steel, shall be effected on or before 26th of June, 2026. The case of the petitioner herein is that the petitioner was granted was permitted to carry out a subcontract
By letter dated 3/5.
under the respondent number 5 by the respondent numbers 2, 3, and 4. The petitioner thereupon carried out the said contract and was issued a final completion certificate on 25/4/2025. However, all of a sudden, without even issuance of any notice, the respondent number 2 have written a letter to the respondent number 5 that the final completion certificate dated 25/4/2025 issued. Wherein, as well as the work order dated 6/4/2019, wherein the mention of the petitioner was made as subcontractor, stood invalidated. And were invalid and stood cancelled. Mr. R. Sharma, the learned senior counsel appearing on behalf of the petitioner, submitted that the respondent number 2, 3, and 4 could not have taken such a unilateral decision, inasmuch as the said completion certificate, which was issued, created rights in favor of the petitioner as credentials for future contracts. He therefore submits that action on the part of the respondent numbers 2, 3, and 4, and more particularly respondent number 2, to unilaterally render the said documents invalid and cancel was in violation to the principles of natural justice. Considering the above, this court therefore directs the respondent authorities to bring on record their stand by filing the affidavit on or before 17th of July 2026. Liberty given to the petitioner to file reply.
My lord,
You have come after 7 months.
my lord, but this is affecting the already the work that is going on.
7 months, 7 months.
We have filed a representation, my lord.
And want this court by an interim to go with that?
No, my lord, what has happened, it is affecting my other work, my lord.
Sorry. No way out.
Obliged, man.
কি মোশন নেই মোশন কি আছে নোটিশ
I appear for the AGCL matters.
Huh?
AGCL, respondent number 2 and 6.
Yeah, why it has come up for motion?
Lordship, it ought to have come for admission, Lordship.
Huh?
It ought to have come for admission. Lordship.
I
I
filed a
think
response.
because such a long
What are the classic name?
affidavit you have filed.
I filed, man.
And Lordship, we are filing the affidavit in reply, Lordship, to the affidavit in opposition filed by them by today, Lordship. So may I pray the matter
You
will
have
come?
filed the affidavit in opposition on 4th.
Yes.
Yes, they have filed, Lordship. And today we are filing the reply, Lordship.
You're filing the reply.
Lordship.
Okay, what is the matter about?
Well, there's a high voltage construction electricity line, my lord, which which is proposed to be constructed over the land of the petitioner, my lord. He had earlier approached his court. He wants his lands to be exempted from that below that line, my lords. But we conducted 2 technical surveys, my lords, which say
There is an interim order.
and there is an interim because, my lord, there's a outer limit of 90 days. Which expires next month.
So we need to finish up the matter early.
Yes, my lord. But one of crucial was stand of the government, my lord, because the government has to, if, my lord, we have to examine his lands, something has to come
Yes,
from the
Mr. government shall also place the affidavit. Why haven't you filed the affidavit? Huh? Well, let us see the face of the district commissioner. Where is he? We have passed the direction upon the district administration shall also place their stand by filing the affidavit as to whether any other feasible route through the government land is possible, and whether the district administration would have any objection in permitting the petitioner to accommodate the two families on the petitioner's land. Oh, I remember this matter.
Yes, Lord.
Where one part of he wants it is in his own place.
Yes, sir.
He has some other land, not to go through that land. Yes, you are the main person. Then tomorrow, day after. Obviously, we are nearby at the vacation. We need the matter to be done as early as possible. With certainty. You file your reply.
Lordship, we are filing today, Lordship.
Oh. This court takes note of that by an order dated 27/4/2026, notice was issued. And as such, the instant writ petition ought to have come up for admission. Be that as it may, it is being seen that the record shows that the respondent number 2 have already filed an affidavit in opposition. The petitioner, the learned counsel appearing on behalf of the petitioner, submits that a reply thereagainst have also been filed today. However, it is noticed that the respondent, the district administration, at whose behest or for whose actions the instant proceedings have been initiated, in spite of being directed, have not filed the affidavit in opposition. First, it is also of the importance to take note of that the affidavit of the district administration is essential, more particularly in view of the reasons so assigned at paragraph number 9 of the order dated 27/4/2026. List this matter again on 22nd of June 2026. The district commissioner is directed to bring on record its stand by filing the affidavit on or before 18th of June 2026. Failing which, this court shall construe that the office of the district commissioner, Hojai, have not been aiding in this an early and expeditious disposal of the present proceedings. Oh,
Yeah, my lord, in this case, my lord, against this package, my lord, the lordship will earlier pass an order, my lord. That order, relative portion of lordship will find at page 91, my lord.
what?
Thereafter, my lord, what happened, my lord? While the one court was is to issue, my lord, they have not to take, not to ever like contact to other person, my lord. They have again, my lord, their petition pending, my lord. Now they have come up with their page 92, my lord.
Pursuant to notice in writing, it is the case of that the beat of the petitioner was technically unable to the same respective the current form. The further case of the growth of technical information evaluation is carried out as part of the environment. Till the contract is not in different things. Oh, lower. So not to give it to anybody except you. Now what happened?
Now, my lord, they have again cancelled my details. Cancel mail. Kindly come to page 92, my lord. And the ground was that, my lord, the beat validity. Can come.
Lordship, as per the last court order, Lordship, passed in this matter, Lordship, I am supposed to produce the records. Records are with me. Everything will be clear.
Mr. Dekha, the only problem is that this court doesn't feel it very proper to see the records without.
Lordship,
appearance of
because
notice.
if your Lordship permits me, Lordship, the thing is that after issuing tender of this work or this particular work, later on it has come to the knowledge of the department by the letter that executive engineer has issued, where he has stated that some more works needs to be implemented in this work, in this particular tender, as there are some some portion of the land has already been taken away by the river. Photographs also annexed. Looking at that point, Lordship, now the department had think that some more works to be implemented in this present tender, Lordship. That is why they have cancelled that tender and a fresh tender will be issued, Lordship.
So
Everything
your reasons are different from what is the reason given in that.
the bid validity is also one of the reasons, Lordship.
You could have very well asked for extension.
Lordship, bid validity is also one of the reasons, but the more particular reason is that some more works needs to be added in that particular tender, Lordship.
Now, have you channelized how much of works are required?
Yes, there is, Lordship.
You have done it?
Yes. Records there.
So you have not issued a new tender?
No. New tender has not been issued till date, Lordship, but we will be issuing new tender, Lordship.
Hello, we do one thing. You file your affidavit
Lordship.
on this aspect.
Lordship, I will.
You don't seem to be in a hurry.
Lordship, we are in a hurry because
No. Obviously, it has taken so much long time for finalizing. Now, before cancellation, is it the basis for going for more works or is it after cancellation?
no, before cancellation. It's there in the record, Lordship. Before cancellation.
Okay, we stay.
Lordship, if Lordship stayed, then it will be a problem for the department, Lordship, to issue a fresh tender, Lordship. That is why, Lordship.
Don't issue a fresh tender, why? Anyway, the government, your water resource doesn't have money. Do you have money?
Lordship.
Do you have money? Or is it the central government?
No, this is the central government fund.
Then therefore, have you informed the central government prior to this cancellation?
No, sorry, I'm sorry, Lordship. This is the state government fund, Lordship. Fund is already there.
So state government doesn't have money, no problem.
No, already fund is there, Lordship. That's why they have issued the tender.
So when you increase the fund, because the work, if it becomes more, have you looked into this?
Lordship, may kindly peruse the record, Lordship. My
We
request.
issue notice and state. We won't see the records now. But if you come up with different reasons, then unless you have your basis for in the original order.
Yes, Lordship. It's a mistake that is being committed in the tender cancellation notice. But if that been stayed because flood season is nearby, Lordship is also aware.
Notice mistake, we'll see. If these are different reasons, then obviously, now if we have developed reasons which is beyond what is there, a case of arbitrariness comes in. Issue notice and state until further orders. Issue notice making it returnable on. When?
Within 3 weeks, Lordship. 3 weeks. Let's see.
On 24th of June, 2026. Extra copies of the Mr. Arendas accepts notice on behalf of the respondent numbers 1, 2, and 3. Extra copies of the petition be served during the course of the day. The petitioner herein is aggrieved by the communication dated 27/5/2026, whereby the respondent number 2 had cancelled the tender of the scheme mentioned in the NIT dated 26/8/2025 on the ground of expiry of the bid validity period. What is your ground?
My lord, it is expressly illegal, my lord, because my lord, what happened, my lord? Earlier, my lord, your lordship will remind now.
That I remember. Now my question is, can they not reject it?
My lord, they cannot reject it. Sir, I will tell you, my lord. What happened, my lord? They are filing this petition. My earlier request is pending, my lord. I had submitted, my lord, one photograph, my lord, color photograph, my lord. Wherein, my lord, they had already, my lord, handed over the work to another person, my lord. He is cleaning the site. Now, my lord, they are coming up with the bid validity period, my lord. And this financial bid.
The learned counsel appearing on behalf of the petitioner submitted that the said ploy taken by the respondent authorities is just to grant the contract to some other persons, and having not been successful to do so in view of the order dated 22/5/2026 in WPC number 2695/2026. On the very next day, the respondents have cancelled the tender.
Yes.
This court also takes note of the submission of Mr. R.M. Das, who appears on behalf of the Water Resource Department, who submits that on account of the scope of the work having enlarged, the work in question had to be cancelled. He submitted that this aspect is apparent from the records. It is the opinion of this court that the said aspect be brought on record by filing affidavit by the respondents, inasmuch as the submission which is being made by Mr. R.M. Das, the learned standing counsel of the Water Resource Department, based upon records, is not the reason which is mentioned in the cancellation notice dated 27/5/2026. An issue all further arises as to whether the cancellation notice is just for the purpose of circumventing the order dated 26/5/2026 in WPC number 2695/2026. This aspect can be seen only on the basis of an affidavit to be filed by the respondent number 2. The affidavit be filed on or before 19th of June 2026 with advance copy to the learned counsel for the petitioner. Petitioner would be at liberty to file reply on or before 23/6/2026. In the interim, this court further directs the respondent authorities not to take any further steps for calling for a fresh tender in respect to the said work, which is the subject matter of the impugned cancellation notice dated 27/5/2026 till the next date.
Lordship, in fact, if your lordship permits me, would like to submit that all this development takes place after receiving of the latest from the executive engineer on 25/26. It's in the file, in the record. After that only.
It's okay. It's okay. You bring it on record.
Lordship.
But he is submitting, you have to bring it.
Lordship, my stay has been granted, that's why. If
Ahmed. He 1,54,833 is pending against him, your lordship.
Right?
Lordship, this is same that Jal Shakti matter, your lordship, and they are not made party, your lordship. We are trying to make the payment in the current financial year, your lordship. I've taken the stand, my equity.
Others have got it, why not him?
Lordship, he also got major part, he has got, your lordship, 8,31,871 his bill amount, your lordship. Out of that, 6,77,038 he has received, your lordship. Leaving balance amount 1,54,840.
And the same will be released in the current financial year.
Yes, your
This
lordship.
one. So we wait for some time, let us have it
Yes,
after
sir.
3 months.
Yes.
This court duly takes note of that pursuant to the order passed by this court on 27/4/2026, an affidavit has been filed on behalf of the respondent number 4. From a perusal of the said affidavit, it is apparent that out of the total bill amount of rupees 8,31,871, an amount of rupees 677,038 have already been paid to have already been paid. It is also seen that the petitioner here, number 1, petitioner number 2, petitioner number 3, and the petitioner number 5 have already received the entire amount. However, as regards the petitioner number 4, an amount of rupees 1,54,833 is pending. And it is mentioned that paragraph number 7 of the affidavit filed by the respondent number 4 that the same would be released in the current financial year, subject to availability of the funds and completion of the required formalities. Under such circumstances, this court fixes this matter again on 23rd of September 2026. In the meantime, the respondent's hearing shall take due steps for clearing the said amount of rupees 154,833, which is due to the petitioner number 4. And Mr. Tripulas Raman, why on earth have you filed 4 petitions, or 5 petitions and 1 contempt?
Common order.
So what? Everybody has a separate cause of action. We do one thing. After you get the money, then you have to disburse 50,000 as cost.
Can we see the order dated 12/12/2025? 12/12/2025.
Who is the now new chief engineer?
Yes, but under that sort of follow-up.
Yeah, why haven't you paid?
Our financial sanction has been awarded. We are just any day, my lord, amount will be credited to my.
Mr. Thakur appearing on behalf of the Chief Engineer PHE Sanitation Department submits that the financial sanction has already been granted and the petitioner would be disbursed the amount and to which he is entitled to any day. Considering the matter, let this matter, considering the above, list this matter on 23rd of June 2026 for an update.
24. 24.
24.
We are complying in the current financial. Current financial year will comply. In fact, Lordship, last financial year, Lordship, the whole proposal was prepared only because of GST number was not submitted by the petitioner.
So what you say means it will be complied.
We are complying.
Have you complied or we are?
We are complying.
No, not we are. We cannot do with we are. It has to be complied. When are you complying?
Lordship, in this financial year, any
Financial year have started.
Lordship,
Then
Lordship, as and when the financial portal is Lordship
you
open.
must have got an idea what order I have passed with Ms. Ardeka. And therefore you are making that submission.
No.
This is not on the basis of an
This
affidavit.
is my
Tell me to
submission.
file an affidavit.
I'll-
File an affidavit.
Lordship, I'll file my affidavit.
Mr. N. Upadhyay, counsel appearing on behalf of the respondent,
Number one.
number one, submits that the petitioner would be paid his dues, his or her,
His
his dues during this current financial year. The said submission, in the opinion of this court, is not in consonance with the directions so passed in the order dated with 3/3 or 8/3.
3/3.
Huh?
3/3.
3/3/2025 in WPC number 1371/2024. Be that as it may, an affidavit be filed on behalf of the respondent number one.
No.
Within giving an undertaking within 7 days from today.
The undertaking is that the plaintiff, the petitioner don't have the GST number. So here is problem.
No, but mention it.
Loss.
That you are giving the undertaking subject to submission of the.
Loss.
You mention it.
Loss.
List this matter on 22nd of June 2026.
Oblige.
My lord, order was already complied with, my lord. Complied.
It has been submitted by Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, that the order dated. Which order?
Last.
Order dated, this one. 2/5.
Page 10.
2/5/2025 in WPC number 1166/2025 have already been complied with. Mr. Dina appears on behalf of the respondent. Considering the above, the instant contempt proceeding stands dropped.
Oblige.
Your Lordship, the petitioner and respondent are members of a joint venture, Your Lordship. They had participated in a bid before the NF Railways, Your Lordship. And this matter was earlier decided on 28th of August, Your Lordship, wherein an undertaking was given by the respondent.
What is the contempt?
Your Lordship, on the 28th of August 2025, the respondent had made an undertaking that for disbursement of funds from the JV account, they will sign a check. It has to be jointly signed
the check has to be jointly signed, Your Lordship. Now, Lordship, they have refrained from signing the check, and they had signed the check. They instructed stop payment instructions to the bank, Your Lordship. Page 20, Your Lordship. Your undertaking.
What happened to the writ petition?
Your Lordship, the writ petition was disposed of, Your Lordship. Thereafter, an IA was filed in the writ petition for clarification of order. And the 28th of August 2025 order is that order, Your Lord. Para 20 of this your order, Your Lordship. Page 20. Sorry. Page 20, para 11, Your Lordship.
The service not complete.
We have done this service.
The
That's
court takes note of the office note dated 5/6/2026. Wherein it is mentioned that the steps for service of notice were received only on 2/6/2026. Considering the above, as the service is not completed, list this matter upon completion of the service.
a short date may be given, Your
I
Lordship.
can't.
I-
You have taken, you got the order on 18/2/2026. You took steps on 2/6/2026. Fine. Yes.
My lord. Item 33, my lord. The matter relates to the release of security deposit money, my lord. On the last date, your lordship had asked us to take steps by way of dusty, my lord. We have filed affidavit, my lord.
Then
My lord, we have served it on, my lord, 5th of May.
service not complete.
My lord, we have served by way of dusty, my lord. We have filed affidavit, my lord.
You filed.
Yes, my lord. We have filed it on 6th of May, my lord. We have served on 5th of May, my lord.
Who is the contemner?
My lord, it is the chief engineer, my lord, Rotikanta Pegu, my lord. He is the chief engineer, PWD, my lord. Border roads and NEC works, my lord. It is the 4th date, my lord. On the earlier 2 occasions also, the learned additional advocate general Mr. Gogoi had appeared, my lord. And he has sought instruction from the chief engineer, my lord, but he did not provide any instruction, my lord. The earlier orders will reflect it.
Yes, what is this?
Lordship, if possible, can this matter be taken after some time? Lordship, Ms. P. Gogoi, he is doing this matter. He's on legs in court number 7, Lordship. After some time, Lordship.
Your name is also there.
Yes, Lordship.
Then why haven't you made the payment?
Lordship, actually,
Amount was payable in the year 2016, my lord. And lordship will find the 11th portion of the order at page number 22.
Okay. What is the amount?
Amount was, my lord, 27,25,000.
And interest?
And interest, my lord.
6 lakhs, 6%?
6%, my lord.
Lordship, the date the petitioner shall carry interest at a reserve from the date the petitioner as per the contractor was entitled to the refund. So what is the interest? Who is going to pay? The contemner has to pay.
As per tender conditions, my lord.
You have not filed the affidavit. Why?
Lordship will file our affidavit in that case. Lordship will file our affidavit in that case.
Why haven't you filed? Because we are going to initiate a contempt now.
Yes, Lordship.
I given a chance. You have not filed your affidavit. So we'll dispense with the appearance of the counsels. He has to appear by name.
In that case, Lordship, they
Sorry.
pass after some time.
No.
Because
This is not a very easy case like this.
Lordship, we have also received for the calling of the pairwise instruction from the
I'm not, this is not a simple day.
Yes, sir.
You received it on 5/5/2026. Today is after 1 month.
Lordship. But this communication that we have received is from 13/5/2026.
No, I'm not on that.
Lordship.
This is not a, this is a contempt.
Yes, Lordship.
So you are doing it by person. Earlier it was by Mr. B. Gogoi. Therefore I said, na,
Yes, Lordship.
so and so is dispensed with.
Lordship.
The appearance is dispensed. We dispensed with. So it needs to strike out the name. I have asked them to strike out the name. Now he has not filed the affidavit and purging the contempt. This court, by an order dated 27/4/2026, categorically observed that this is a fit case for initiation of contempt proceedings against the contemner. And directed the respondent to show cause, the contemner to show cause as to why contempt proceedings should not be drawn against him for willful, deliberate violation of the order dated 19/11/2025, passed in WPC number 3028/2025. The records further reveal that this order was duly served upon the petitioner, upon the contemner on 5/5/2025. 26. And in spite of that, the contemner have chosen not to file the affidavit in opposition, an affidavit showing why contempt proceedings should not be drawn against him. Considering the above, as the contemner have not purged with the contempt which is the requirement by filing an affidavit, this court would not be permitting the contemner the services of the advocate, and the contemner has to personally appear before this court. List this matter again on 22nd of June 2026 at 10:30 a.m. The contemner has to be physically present in the court.
At a similar brain attempt number 34, my lord. Same contempt, no matter. Hello.
Wait, please, Your Lordship. Under this contempt petition, my lord, we have filed our affidavit, my lord. That's fine. Please may kindly see order dated 17/2/2026, page 16, my lord. And operative portion, my lord. Page 23, para 13, my lord.
What happened to the writ appeal?
My lord, we have filed our affidavit. Writ appeal, my lord, not registered. I have
But
checked, my lord.
page 63.
You have filed?
We have filed our affidavit. Short time may be granted, my lord.
You have not filed?
My affidavit has been filed, writ appeal also filed, but not registered yet. I have
My lord, writ appeal was filed on 18/3/2026, my lord, page 63, my lord.
You may submit it on 29/4/2026.
Yes, that
Yes.
was already filed, my lord, but because of some translation and some illegible copies.
That
was
I also know why you have got it done in that manner,
My lord.
filed it in that manner.
No, my lord.
Absolutely.
We have filed our
In
affidavit.
category, in the meantime, if interim orders are passed by the learned division bench, the same be placed before. Otherwise, the shall bring on record the stand by filing.
We have filed our affidavit.
Where is it?
My already filed, my copy has been served.
Affidavit filed, my lord. But that they stated, my lord, by annexing, my lord, one, my lord, a writ appeal was filed on 18/3.
That is not the ground, my lord.
18th, mere filing the writ appeal cannot be the stay, my lord.
That is not the ground, my lord. We have not.
18/3.
What is the affidavit say?
Affidavit says, my lord, immediately after the passing of the judgment, my lord, we have placed that in our board meeting, my lord. And board anonymously, my lord, decided to file an appeal, my lord. That is why.
No, that can't be a defense.
Because
that can't be a defense unless you get your appeal registered.
Lordship will see, my lord, whether deliberate willful violation is there or not, my lord. Lordship may kindly have giving some time, my lord. Lordship may fix the
In
matter
spite
after
of receiving the court order, they issued it, my lord, extension order with the same my private respondent.
That was passed before passing of the earlier order, my lord.
Fully, my lord, contempt,
Contract
my lord.
awarded to us admittedly being so done, basing on criteria foreign to the stipulations. Now tell me, this market is for how long?
Well, that was original period is already infructuous, my lord.
Then what do you mean?
Before passing of that order, one extension order was passed because at that time model code of conduct was there. Model code of conduct was there, so extension was there. That is why they are still.
Now, are you still allowing the respondent?
Yes.
Allowing them, him.
Before passing of that order, my lord, last
No,
order.
it has already been set aside.
Set aside.
My lord, set aside earlier order, but before passing of that order, my lord, one extension order was there, which was not challenged.
That was suppressed before the
No,
full
no.
court, my lord. Backdated, my lord, the affidavit. Backdated, my lord.
We take
He's
it
the
up.
chairman
Yes,
of the.
this
Yes,
is not the-
totally
Violation of the-
Absolutely, this is in violation. Immediately you stop this respondent number 6 to run it.
That I'll,
We have it on again on Friday.
my lord.
Produce the order by you have stopped.
My lord.
Mr. Dotto, you have to be fair. You and your counsel, your client is not fair.
Well,
when it has been set aside, you are still continuing on the basis that you are doing it. It's just, I would have understood the respondent number 6 saying that, okay, he has filed an appeal. Then what has been allowed? That this has been had to be set aside. We have not been able to get it done. The present contempt application has been filed alleging willful and deliberate violation to the order dated 17/2/2026 passed in WPC number 5076/2025, wherein there was a specific direction that the settlement of market made with the respondent number 6 in the proceeding by the order dated 29/3/2025 was set aside, and the Tejpur Municipal Board was directed to undertake a process of fresh settlement of markets for the remaining period by resorting to a process of draw of lots amongst the eligible bidders who have submitted their bids in pursuance to the notice inviting tender dated 7/3/2025. This court duly takes note of that when the instant proceedings was listed on 29/4/2026, a submission was made on behalf of the respondent that an appeal thereagainst had been filed before the division bench of this court. This court categorically observed by the order dated 29/4/2026 that in the meantime, if there is any interim order passed by the learned division bench of this court, the same be placed before this court. This court also observed that a respondent should bring on record his or her stand by filing an affidavit on or before 1/6/2026. An affidavit has been filed on behalf of the respondent stating only the defense that an appeal has been filed. Footstep. This court inquired with the learned counsels appearing on behalf of the respondent as regard the fate of the respondent appeal. and it is being submitted that the appeal is still defective. And as such have not been listed before the learned division bench of this court. It is the opinion of this court that when a defective appeal is filed, it cannot be regarded that an appeal has been filed in accordance with law. This court further is shocked to learn that in spite of the specific directions passed by the learned coordinate bench in the judgment and order dated 17/2/2026 in WPC number 5076/2025, the respondent in an utter contemptuous act is still permitting the respondent number 6 to continue with the market in question. This is a case of a clear contempt, and this court was inclined to pass an order of drawing up contempt proceedings against the respondent when Mr. S. Dr., the learned counsel appearing on behalf of the respondent, submitted that corrective measures will be taken in a day or so. List this matter again on Friday.
15 value.
Huh? On 15th of June 2026 for an update. Mr. Yeah, I'm not taking it up, doing it, but you asked them.
My lord.
Immediately.
My lord. 36, we have filed our affidavit, my lord.
Whether in the area wherein the petitioner as well as respondent have been settled with very service and ICC or Zaria has the jurisdiction, can be effectively adjudicated only upon respective stand of the area being brought from the court. Your file affidavit.
Mercy, we have filed and I have received some updated instruction
What is that?
regarding the joint survey and status of the ferry service.
Based on the affidavit of the Imam, the video is partly showing the accusation. Okay.
Lordship, the last annex, Madam, may kindly have a look. That notification issued in the year 2022, and this notification is not under challenge till now. If they have the jurisdiction, they will have to challenge the Panchayat department or some other party.
You are running from?
I am running. 31st May was the last, but I have been given an extension till 15th of June. I received the
Understood, but I'm asking you.
24 now.
You are running your area of.
It's 24.
The route is?
Adabari, Sialmari, Kuhimari ferry services.
And you are under IWT?
Yes, they have given me them.
Panchayat? You are the main cause of problem, Mr. Datta. Then,
Well, both are outstanding, both the manner in the different district, although nearby, but the routes are different. Routes are different, not the same. And we have, for joint survey, we have.
No. Who is the authority above that?
Lordship, the notification, my lord, may kindly.
No, madam, but this your notification it's an order.
Lordship.
By the director IDWT.
Lordship.
Now you are fighting and he is fighting.
My lord.
So both of you are fighting out there. So who is the authority above both of you?
Government Chief Secretary, my lord. Chief Secretary.
Chief Secretary.
Lordship may dispose of the matter and direct the Chief Secretary look into the matter, because both the department is fighting.
Chief Secretary is
Not fighting exactly well. Because not exactly fighting, but only solution is very good. Yes. Because there is a rule within that manner area we our route is there, we don't have anything. So the secretary we cannot issue any assessment.
In fact,
One verification will verify everything.
in fact, Lordship may kindly have section 4 of Northern India Ferries Act 1878. The department has jurisdiction to declare any
One joint verification happened, but they could not complete it, my lord,
Because of
because
the
of
dry
the
season.
dry season. They could not do it. There was something that happened. That they have in fact bought it on record also. my lord.
Page 57 is the type copy of the last minutes of the joint meeting.
Yes, my lord, that they have filed it here.
So this is by the local government.
Yes.
You are local government.
Lordship, the transport department may Lordship.
Transport, IWT is transport, no?
Yes, transport.
It's under the.
Yeah, under
It's
transport.
under-
You are, what is IWT? Director Inland Water
Water
Transport.
Transport.
What is that?
Lordship, it's a wing of
It has to
transport
be done
department.
by the transport department. The government is to do.
Yes.
Then let it be done by this transport. Who is the highest authority?
Commissioner Secretary.
You have a commission, not additional chief secretary. You have not got it.
Lordship, so far my knowledge is concerned, our
Everywhere there is an additional chief secretary.
Commissioner Secretary. I'm not aware whether he's additional.
Like in some states, we have a lot of deputy chief ministers. In Assam, we have the culture of having additional chief secretaries.
Lordship may direct the
So we do one thing, the best option would be directing the commissioner and secretary because they have the authority
Yes.
to define as per the Northern Indian Ferry Act. So let him decide
Yes.
and place a report before this court
Yes.
after 2 weeks.
My lord.
Better not.
Lordship.
Heard Mr. So-and-so, the learned senior counsel, assisted by Mr. K. Mohammed, the learned counsel appearing on behalf of the petitioner. Ms. N.D. Bora appears on behalf of the Transport Department.
Respondent number 2, 3, 4, and 5.
S. Dutta appears on behalf of the Panchayat Department. And Mr. R. Sharma appears for respondent number 10. The dispute in the present proceedings is on account of the petitioner being not able to run the Adabari, Sialmari, Kuhi or Kuri?
Kuri Hamari.
Huh?
Kuri Hamari. Kuriha. Kurihamar.
Kurihamari.
Yes, ma'am.
Ferry service. Which have been allotted to the, settled with the petitioner on account of the Hajo and Salik Panchayat having settled with the respondent number 10, a ferry service, which as per the petitioner overlaps with his route. This court duly takes note of that as per the Northern Farriers Act of Northern Indian Farriers Act
Yes. 1878.
1878, it is the state of Assam who has the authority to define the ferry routes as would be available, as is seen from section 4 of the said act. Considering the above, this court therefore directs the commissioner and secretary to the government of Assam Transport Department to verify as to whether the ferry service, the route of the petitioner, that is Adabari, Sialmari,
Kurihamari.
Urihamari ferry service is affected on account of the route permitted to the respondent number 10 by the Hajo Anchalik Panchayat. And thereupon also decide as to who would be entitled to run in that specific route. The above directions is based by taking into account the submissions made by Mr. S. Dutta appearing on behalf of the Panchayat Department, who submits that the route provided to the respondent number 10 by the the route settled to the respondent number 10 by the Hajo Anchalik Panchayat is different from the route which have been granted settled with the petitioner. List this matter again on 17th of July 2026. In the meantime, the report be submitted before this court by way of an affidavit on or before 15th of July 2026. The interim order passed earlier shall continue till the next day.
That extension, my lord, the letter says that every 15 days will be given to us. So that extension, I think 15
The
June.
problem is, no. The problem would not be infectious because tomorrow you are going to do the same problem.
Yes.
Yes,
Absolutely.
So then it will get clear.
Obliged.
What is this I business?
Is for modification, Lordship.
What? For correction?
Yes, Lordship.
No.
But
They are strongly opposing it.
But my prayer clause, I have that I'm marked in devoter in the district of Kualpara, which is my native
But
district.
there is a considering the fact that there is already a FT case being
that
FT case number registered against the petitioner. It is only the court that can decide as to whether.
That I will appear if it's, but my devoter owns her, but devoter is in Kualpara. So I need a direction to the SP border Kualpara. If this case I receive a notice, I will appear. But my devoter will not suffice. So my devoter is in Kualpara.
Do you need so many types of different types of area? In every place there is a devoter, there is a different foreigners tribunal going to do it. It has to be one. Now, if this FT case is decided against you,
then I will get another notice.
However, it is the stand of the petitioner as submitted by the learned counsel appearing on behalf that no notice has been received. And it therefore the opinion that no directions can be passed in the present case, they were directed to remove the ER against the name of ER till FT so and so is resolved. What happened to FTT so and so?
FT case, if it's resolved, also my devoter won't be resolved, Lordship.
Why?
Reason is that I am a native of Gwalpara district. So wherein my name is enrolled in that area. And I'm not marked as devoter in Kamrup Metro. There might be an FT case that I admit also.
There cannot be 10 FT case.
Yes, there is, Lordship, and which is pending before one of my cases.
You go for transfer of this FT case from one court to the other, that you can do. Very well, go ahead. But this court is not going to allow this type of.
Lordship, my prayer in my writ petition is that I'm marked as devoter in Gwalpara district, not in Kamrup. That is a not.
What?
So if I'm declared,
my question is
yes, Lordship.
If you see there are many directions why a devoter happens. First, a devoter happens in view of the 97th SIR.
Yes, Lordship.
That was the initial.
Yes, Lordship. Yes, Lordship.
Then comes the judgment of the of Justice B.K. Sharma to that effect that anybody whose cases are pending before a foreigner's tribunal, their name should be marked with a Mameza Khatu. Okay. Now, your case is pending there. Obviously, your name will be D.
No, Lordship.
Yes.
If I am declared as Indian also in not a foreigner in this particular case in Kamrup district, but D, which is marked in my native district, where I am from, it won't go. There has to be another proceeding there.
No.
So, yes, Lordship. Because
Show me that. Show me that. What type of procedure has election commission changed that? No.
There are two kinds of proceeding before the FT. One is D-voter cases and one is FT cases. FT cases means when a migrant worker goes to one district. I can give one order also, Lordship, wherein I got an interim order. There are two separate proceedings in two districts. And Lordship, I can just mail that interim order, which reflects that D-voter is there in his own native district and there was an FT case.
With due respect is not correct. That interim order does not take care of the edifice on which a D-voter happens. There are only two reasons when a D-voter happens. The first is when the VLO makes an investigation, he places before the electoral officer. The electoral officer thereupon says that yes, it is doubtful, and thereupon refers it to the police, SP police. He makes the reference out there.
Yes,
and
Lordship.
he becomes a D-voter.
Yes.
That is one.
That
the
is
second is when there is already a case pending before the FT, then he becomes a D-voter. The logical corollary from this is once that FT case is done, you will be and you are being declared a year, your D will be removed.
Then I have to face another proceeding.
No, you don't have to.
Yes, Lordship.
There cannot be.
I have to face another proceeding in Gwalpara district.
No.
For,
And if you face, Miss Ghosh, if you face that, you come before the court will pass an order. But as of now, I don't think.
And in fact, in the inquiry report, they have dropped it, which I have annexed, Lordship. They have dropped it. Inquiry is at page 49 of my writ petition. 49 of the writ petition, Lordship.
Writ petition. What is this? What inquiry? Show me.
Page 52, Lordship.
What is this? In the course of inquiry of the said FT case, in the current the case to me with a suspicious name.
What is the DCPO's opinion? Since
what is this document?
this is an inquiry being conducted when I was there as a migrant worker. There was they have inquired whether I'm Indian or not, wherein I have submitted all the documents. And in fact, the operating
Now tell me,
yes, Lordship.
This document, you knew that there is an FT case.
Yes, Lordship. I have submitted all the documents there.
So the FT case is there.
And they have
Has
said
the FT case been dropped?
it's written, maybe drop, supervise the case.
No, who is going to drop? Who can drop a FT case? It is, madam, it is a reference. A reference has to be answered. Either there is a case, he is an Indian citizen, he is not an Indian citizen. That is to be done by the FT, not by this inquiry officer business.
Inquiry I have, because they themselves.
Value.
If they have done also, but my D-voter mark will be there in my own native district, Lordship.
No, once you get an opinion in your favor in 205.
Yes, Lordship.
And I make it very clear that once you come up with an opinion in 205 that you are an Indian citizen, your D will be removed. Okay.
Yes, if that is there, then I will submit a representation before the election officer Gwalpara that I'm declared as not a foreigner in this particular case. So my D marked in Gwalpara.
Dependent upon the opinion.
Yes, after the opinion. After the opinion, Lordship. That will suffice because then there won't be a separate proceeding in
There cannot be a separate, there cannot be two proceedings, I'm telling you. Heard Ms. D. Ghosh, the learned counsel appearing on behalf of the petitioner. None appears on behalf of the on behalf of the Union of India or the State of Assam or the Election Commission of India or even the National NRC when the matter is called. Mr. So-and-so appears on behalf of the Home Department. This is an application filed for modifying the order dated 3/12/2025 passed in WPC number 6794/2025. First and foremost, this application is not maintainable in as much as it is a well-settled principle of law that there cannot be a miscellaneous application filed in respect to a disposed of matter. Be that as it may, this court duly takes note of the submission made by Ms. De Host, the learned counsel appearing on behalf of the petitioner, that the petitioner has been marked D in the Gwalpara district.
Yes, 39 Joleshwar.
Where the petitioner is a voter in the 39 number Jaleshwar Legislative Assembly constituency. Whereas the FT case number 205/2018 has been registered at Gauhati, Kamrup Metro, Assam. The learned counsel submitted that there is a requirement of another reference to be made for the marking of the de-voter of the petitioner in before the FT, Foreigners Tribunal, Gwalpara. The said submission is completely misconceived in as much as there cannot be two proceedings as regards an adjudication as to whether the petitioner herein is a citizen of India or not. It is the opinion of this court that the decision in FT case number 205/2018, if made in favor of the petitioner, the same would duly cover the case of the petitioner in respect to removing the name of removing the remark D against his voters list. Accordingly, the instant application being misconceived, the same stands dismissed. Recheck.
May I please, your lordship, the conducting counsel have personal difficulties, so he's left the court. Lordship, I pray for some time. Also, they have filed one IA. I have to reply in that IA, lordship.
Who has filed this IA?
IA has been filed by the FCI, Food Corporation of India, lordship, for striking of respondent number 4.
Huh? IA filed by Mr. B.K. Singh.
I am appearing on behalf of Mr. B.K. Singh.
What is this IA for?
For striking of the name of the respondent number 4.
Why?
In the prayer, it's not mentioned about the CMD. In the prayer, it's not mentioned about the CMD.
You are for the?
Lordship, I am for the petitioner. Lordship, I am appearing on behalf of Mr. D. Rakhi, lordship. He has left the court, lordship.
You are appearing for?
On behalf of Mr. D. Rakhi, for the petitioner, lordship.
You want to file a reply?
Lordship,
We
in
have
the
to notice.
lordship.
Issue notice making it returnable within making returnable by 27/2026. Mr. H. Gupta appears on behalf of Mr. So-and-so appears on behalf of the opposite party number one.
Lordship.
Mr. H. Gupta appears on behalf of the opposite party number 2, 3, and 4. Huh?
In the
No.
In the-
IA, you become 2, 3. Accordingly, the extra copies of the instant application be served upon the respective councils. The respective councils shall be at liberty to bring on record their objections, if any, to the instant application.
Much obliged.
If they have filed an affidavit in terms of order filed by the law.
What happened? What did they say?
They say that the reapplication is not maintainable and government has no obligation because the transfer has been made. These are the contention. In lordship, it's a date. Gogoi was there.
Who is appearing for the respondent? Yes. Mr. Bigogo, you appear for the Industries Department.
Today affidavit has been filed.
Now, tell me one thing, Mr. Gogoi. This Assam yarn is nowhere available. Okay. Now, if Assam yarn is not available, what happened to the machineries? What happened to the entire area which was transferred? My question is that, because you see, the entire thing is, there's nothing. There's no existence that we could find out. The resident commissioner of Mumbai categorically says that there is no, they traced it out, they couldn't find any trace of this Assamian. So therefore, what happened there? What happened to Apple? It is, at one point of time, it was an industry. It may have been transferred in the year 2001 to these people. It is one thing, but they are nowhere to be seen anywhere. You look into this affidavit, what can be done in respect to these? Because these are people who are the employees. They may have signed out there. But as of this, and by way of an agreement, how such a transfer could happen is another aspect. They have, and what is the agreement? They will do so by paying only taking over the liabilities. 1 lakh. Not. They have only paid the government 1 lakh of the entire Apple. So the question is, if nobody is there, why you are not exercising your right of doctrine of escheat? Take over. Find out that this is a very important thing. You are now, we are not, you see, The case of the petitioner is too meager a small an amount. Apple was at a very good location at one point of time. If this person whom you have handed over is nowhere to be seen, what happened there? Is it in existence or not? If it is nobody is there, then obviously you would let the government take it over on the basis of the doctrine of IC. And then the government can do many aspects. They are only asking some 25F. There is a small question pertaining to this. There's a bigger area. Why don't you look into that angle? You are only thinking about contesting this case to the effect that they have nothing out there. They should go have an industrial dispute, reputation not maintainable. They were signatories to this agreement and all. That is a different thing. But what happened to this entire thing? The land was there. Yes. What happened to the land?
Assets.
Huh?
Assets.
The assets, what happened? If this Assam yarn is not there, find it out. Okay. This court have duly taken note of. An affidavit has been filed by the respondent number 1 pursuant to the order passed by this court on 4/5/2026. This court have, the said affidavit have been duly perused. This court also inquired with Mr. B. Gogoi, the learned additional Advocate General Assam, as to what's had happened to the assets of Assam Politics Limited, which was transferred to MS Assam Yarn Supplies on the basis of an agreement dated 4/4/2001. Inasmuch as the very entity of Assam Yarn Supplies could not be traced anywhere. Mr. B. Gogoi, the learned additional Advocate General, submits that you obtained instructions in that regard. List this matter again on 15th of July 2026. This is, you just find out, if it's necessary, if he is not being placed, take over. Where is that Apple was in?
Jagiron.
Huh? No. It is nearby Mongoldo somewhere. Yes.
No, Jagiron Morigao.
No.
The company promoted significant. Yes. Pashchim Nagam Jagirot Morigao. That is paragraph number 1. Factory is there.
Company may be in Morigao or Jagirat, but the factory is there. That is what this is, and this is a very important location. Just stress down. 1 o'clock. That in the circumstance the petitioners in so and so approach the appellate tribunal. Within 30 days from the date of the present judgment, the appellate tribunal shall decide the respective appeals so filed by the writ petitioners in so and so on merits without insisting on the question of limitation. This court further grants the liberty to the petitioner in so and so to approach the appellate authority. In terms with section 107 of the AL, it is observed that if the petitioner in so and so approaches within a period of 30 days from the date of the present judgment, the appellate authority shall decide the appeal on merits without insisting on the question of limitation. This court further observes that the interim orders passed in the 3 writ petitions shall continue till the consideration of the stay application by the appellate tribunal / appellate authority, as the case may be, subject to the appeals being filed by the petitioners herein, as per the liberty granted herein above, within the period of 30 days from the date of the present judgment. There shall be no order as to cost. The other case is a different case. Now here, although it was being submitted in the court that this is covered by, but this thing, in my opinion, 122 1A casts is different from taxable person. It will only involve those persons who retains the benefit as well as at whose instance such transactions have happened. Now, the counsel appearing on behalf of the petitioner had relied upon the two judgments of the Bombay High Court in the case of Hantanu Sanjay Hundekari and Amit Lal Manilal Haria. But I have gone against that. And in my opinion, the judgment of the Delhi High Court in Gurdas Malik Thakur appears to be more appropriate. Though there is a leave granted by the Supreme Court on these issues, I have decided. I have framed 2 points for consideration before this court. Now, you see, these petitioners happen to be the petitioners in the partners of the writ petitioners in WPC number 20/2026, whereby I have granted the partnership firm to appeal. Now, any decision in the partnership firm's appeal will have a bearing. So I could not have confirmed the amount which have been imposed upon them. That will depend, because if I confirm, then in the appellate tribunal holds otherwise, then the question would be different. Anyway, the 2 points for determination in the present proceedings are whether the petitioners in both the writ petitions, who are admittedly partners of so-and-so, can be imposed penalty under section 122 1A of the Act of 2017. In the circumstance, the point number 2, in the circumstance, the point for determination number 1 is decided against the petitioners, whether the provisions of section 122 1A of the Act of 2017 can be applied for the period prior to 1/1/2021, which is the date of coming into force of section 122 1A of the Act. In respect to the first point of determination, I have differentiated. I have stated out there categorically that section 122 1 only refers to taxable person. 122 2 1A is in respect to those persons, any person who retains the benefit and at whose instance this had happened. Then I have taken into account section 284, which defines person, 206, which defines taxable person, and 294, which defines registered person. The 294 is registered person. And held that any person, the Bombay High Court judgment in the case, in those two cases, appears to be a very narrow interpretation, inasmuch as the Bombay High Court holds that the taxable person will be the any person. I say that in the case of a juridical person, the question does not arise, because the juridical person on its own cannot decide the very aspect of the matter. It has to be decided by a natural person, and a natural person, if he retains the benefit, then it is. So therefore, this is the first point for determination. The second point for determination pertains to as to whether it could have been applied, taking into account this period of the notices were from 2017 onwards, and section 122 1A only came into operation from 1/1/2021. The Bombay High Court holds on the basis of article 21, bracket 1, holding that it is an offense which cannot be given retrospective operation. In my opinion, that offense is been mentioned in section 132, whereas section 122 is penalty. Now, the Constitution judgment in Jwala Prasad categorically differentiates what is an offense which will come under article 21. And therefore, I have held that section 122 1A is complementary to section 122 1. And therefore, the offense or the violations were already there when the Act of 2017 came in. Similar like the proceeds of crime business. Whether the schedule offense was brought later on, it is immaterial. But whether that offense has been created as on the date on which the notice has been issued. So therefore, taking into account that I have asked these persons to file an appeal against in the appellate forum. In the terms with section 120, in terms with section 122, 1A of the Act of 2017, penalty can be imposed upon the petitioners unless and until the findings of facts arrived at by the proper officer in the order in original, dated so and so, as well as the appellate authority in the order in appeal dated for the petitioners are interfered with by the appellate tribunal. Section 122 1A would be applicable against the petitioners for any transactions covered under section clauses 1, 2, 7, 9 of section so and so, even for the period prior to coming into effect of section 122 1A of the Act of 2017. The petitioners herein are granted liberty to file respective appeals before the appellate tribunal within a period of 30 days from today. And if such appeal is filed within the said period, the appellate tribunal shall consider the said appeals on its merits without insisting on the question of limitation. This court further observes and directs that if the appeals are filed within the time permitted in the preceding clause, the interim order so passed in the respective writ petitions to the effect that no course of measures should be taken against the petitioner shall continue till the stay applications are taken up for consideration by the appellate tribunal. There shall be no order as to cost. I have framed 3 points for determination. Whether the respondent authorities prior to passing of the impugned speaking orders followed the procedural safeguards mandated by the directions passed by the Supreme Court in the case of Abdul Khalek Supra. If the answer, number 2, if the answer to the first point of determination is in the affirmative, if have the petitioners been able to show any documents or evidence to substantiate their right to remain inside the reserve forest? Number 3, what order directions are required to be passed in the present proceedings? In respect to the first point for determination, I have held that the procedural safeguards have been duly taken note of. As regards the second point of determination, I have dealt with the 3 groups. There were 3 groups. First group pertains to those who have said that these are not revenue land, these are revenue lands, as well as had Aadhaar cards, panchayat, and all these things. The second is pertaining to the Tongia cultivation system, and the third is as to whether certain persons have been granted pattas, so whether they will come in. Now, taking into account the first point of determination, I have held that the petitioners are within the 4 corners of the reserve forest in view of these geo-coordinates. But you, by the way, you should have also put those geo-coordinates with degree, minutes, and fractions of minutes, because then it becomes much easier. But anyways, that is not my view. Now, as regards the first point, I have dealt with all the provisions of the regulations as well as the Indian Forest Act and held categorically that the petitioners have not been able to show any documents in that regard. Now, the third point for determination as to what orders can be passed. This court have duly taken note of that the petitioners have been there for a long time and all these things are there. But then also, their private rights of the rights of the petitioners, which are private in nature, cannot supersede the public rights for protection of the environment. Accordingly, this court passed these following directions. The impugned speaking orders dated 7/3/2026, which are assailed in the present batch of writ petitions, qua each of the petitioners were passed after following the necessary procedural safeguards as mandated in the judgment of the Supreme Court in the case of Abdul Khalik. The impugned speaking orders dated so and so, qua each of the petitioners were passed by taking into consideration the relevant factors and considerations. The findings of fact arrived at by the authorities concerned that the petitioners in the batch of writ petitions are occupying lands within the reserve forest are based upon a proper survey conducted by the committee constituted by notification dated 17/2/2026, along with the forest officials and the digitization of the boundaries of the reserve forest in question. Under such circumstances, these findings of facts cannot be questioned in the writ proceedings. The findings in the impugned speaking orders qua each of the petitioners that the petitioners have failed to show documents and evidence of creation of rights to remain in the reserve forest are in accordance with the settled principles of law as such do not call for any interference. Aadhaar cards, election IDs, names in the electoral rolls, electricity connections, certificate issued by the Panchayat authorities cannot be regarded as documents which would entitle the petitioner to reside within the reserve forest. The notification issued under Section 5 of the Assam Panchayat Act is only a notification extending the benefits of the Panchayat Raj institutions to the reserve forest. The said notification issued under Section 5 would not, under no circumstances, change the character of the reserve forest. The reason being, Section 2 of the Forest Conservation Act categorically bars any state law or any central law applicable to the state from de-reserving a reserve forest or portion thereof without the approval of the central government. A perusal of the provisions of the regulations would show that no rights have been conferred upon the persons carrying Jumin cultivation or under the Tongia system to reside within the reserve forest except those persons who come within the ambit of the forest dwelling scheduled tribes and other traditional forest dwellers as defined in the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Rights Act 2006. Further, no person can claim derivative rights when no rights have accrued upon the persons claiming rights under the Tongia system. Apart from that, there is a bar under Section 22 of the regulation from alienation without the previous sanction or approval of the state government. The petitioners herein have failed to show that they come within the scope of the forest dwellers, scheduled tribes, or other traditional forest dwellers as defined in the Scheduled Tribes Act 2006. And under such circumstances, they have no right to remain within the reserve forest. The petitioners herein have also failed to show that their names have been recorded in the Jamabandi prepared by the Forest Department of the Government of Assam. The revenue authorities of the state of Assam cannot confer any right over any lands falling within the reserve forest by virtue of Section 4 of the Assam Land and Revenue Regulation 1886. Therefore, issuance of any patta or accepting revenue by the revenue authorities in respect to lands falling within reserve forest would not create any right or interest to remain within the reserve forest. All petitioners have failed to show any right to remain within the subject reserve forest. The right to protect the environment and safeguard the forest and wildlife are rights falling within the realm of public rights, and these rights outweigh the private rights of the petitioners to reside within the reserve forest. The petitioners cannot be permitted to reside within the boundaries of the reserve forest which have been specifically outlined by the geo-coordinate locations of each of the reserve forests as quoted herein above. It is the constitutional obligation cast upon the state to protect and improve the environment and to safeguard the forest and wildlife. Under such circumstances, the steps taken for eviction of the petitioners in the present batch of writ petitions as well as all other encroachers by the issuance of notice are in consonance with the constitutional goals enshrined under Article 48A of the Constitution. This court grants a period of 30 days to the petitioners to take steps for removal of their belongings and make alternative arrangements. Failure to do so, this court directs the officials of the state government, including the district administration, the police administration, as well as the forest official to take active steps for removal of the petitioners from the reserve forest in question. This court further directs the managing director and APDCL to disconnect the electricity connections after 30 days from the date of the instant judgment of the petitioner, as well as all encroachers of the reserve forest against whom speaking orders have been passed pursuant to the judgment of the Supreme Court in the case of Abdul Khalek. This court further observes that diversion of lands within the reserve forest are not permissible for setting up of schools, dispensaries, hospitals, Anganwadis, fair price shop, electricity and telecommunication lines, roads, communities, centers, etc., unless the central government provides for diversion of this facility. This court also observed that Section 3(2) of the Act of 2006 provides when such diversion is permissible. Under such circumstances, this court directs the Chief Secretary, Government of Assam, to take appropriate steps for due compliance in respect to the facilities provided within the reserve forest in question, as outlined by the geo-coordinate boundaries of the respective reserve forest, as mentioned in the body of the instant judgment. This court further observes that in the circumstance, on account of compliance, as directed above, any forest dwellings scheduled tribe and or other traditional forest dwellers duly recognized are affected, the concerned authorities of the state are directed to do the needful so that they can avail such facilities in the adjoining areas falling in the government caste lands or private lands outside the reserve forest. The Chief Secretary of the Government of Assam is directed to ensure the same. The Chief Secretary of Government of Assam is further directed to ensure that the Forest Department of the Government of Assam does not permit any use of lands upon being cleared from encroachment for any non-forest purpose. The Chief Secretary of the Government of Assam shall ensure that the Forest Department of the Government of Assam take effective steps for reforestation of the lands upon being cleared from encroachment. This court duly takes note of the maps produced before this court. In the said maps, which contain the photographic image of the reserve forest, the respondents have indicated the possession of the petitioners as well as other encroachers. In view of the findings in the present judgment, there cannot be any person residing within the reserve forest except it is permissible under the rights saved under the regulation, as well as the forest tribes and other traditional forest dwellers' recognition of rights. Under such circumstances, it is the constitutional obligation of the state to evict all other encroachers within the reserve forest by following the procedural safeguards approved by the Supreme Court in the case of Abdul Khalek. This court further observes that the petitioners would be at liberty to apply for allotment of revenue lands coming within the ambit of the Assam Land and Revenue Regulation 1886 in terms with the Assam Land Policy 2019. In the circumstance, the petitioners can show that the petitioners were allowed to settle in the reserve forest prior to 1980 by competent authority. The Revenue Department of the Government of Assam shall prioritize such applications for allotment. In respect to other petitioners, the same shall be done in accordance with the principles and procedure laid down under the Assam Land Policy 2019. Interim orders passed earlier stands vacated. All petitions stands disposed of. Before parting with the record, this court finds it relevant to remind ourselves of the words of our father of nation, taking into consideration the subject involved. What we are doing to the forest of the world is but a mirror, reflection of what we are doing to ourselves and to one another.
Deeply obliged. Deeply obliged, my lord. Obliged.
Yes, madam. Principal Tinkong College. What is the matter about?
Lordship, non-payment of contractor's bill. The petitioner was allotted to construct the hostel of the college.
Yes, madam. Dr. Gogoi.
Yes, sir.
Why these payments have not been made to the petitioner?
Yes, sir. My lord, this is the from the UGC. The grant has not already released. Therefore, we cannot release the grant to the petition.
So you have not got the grant from the UGC.
হয় sir.
এতিয়া পইচাটো
Yes.
কোনে দিব আপোনাক?
হয়তো UGC পৰা দিব লাগিব।
UGC দিব।
হয় sir.
আপোনালোকে have you moved the UGC for that?
হয় sir, আমি এইটো মুভ কৰিছো 3/12/2022 থৈছা 24/12/2020 আমি ৰিলিজ কৰিবলৈ UGC NER ক আমি এপ্ৰ'চ কৰিছো সেকেন্ড ইনষ্টলমেন্ট দিবৰ কাৰণে।
Now UGC কি কৈছে আপোনাৰ ৰিপৰ্টত গম পাইছে নে?
UGC ৰিপৰ্টত তেওঁলোকৰ দিব বুলিও কৈছে কথাটো।
আপুনি paragraph 8 টো চাইছে নে UGC এফিডেভিট খন?
Lordship, in this matter, we have filed an affidavit on 4/6/2026, Lordship. After the petitioner, he gave the bills and everything, Lordship, and the utilization certificate was also given, Lordship. The principal, she wrote to the UGC authorities, Lordship.
Now, have you looked
Lordship,
into the affidavit? Have you looked into paragraph number 8 of the affidavit filed by the UGC?
Yes, that is.
What do they say?
Lordship, on 3/12/2019, Lordship, and on 24/12/2020, we have communicated to the UGC authorities regarding the balance grant of 40 lakhs that has to be paid by the UGC to college, Lordship.
Have you seen the affidavit of paragraph number 8 of the UGC?
The Lordship, that affidavit we have not got, Lordship. UGC's affidavit. We have not received it, Lordship.
To look into that, because what you are saying is different from what the principal is saying out here. The UGC will give the amount, but UGC denies this amount. Kindly
Yes,
see
Lordship.
paragraph 8. That with
Lordship,
regard to the statements in paragraph 5 of the affidavit, the answer in the opponent respects that there is nothing on record that the petitioner has successfully completed the construction work of women hostel of Tingkong College, Dibrugarh under the 12th plan of so and so. UGC had extended the scheme for building construction already started on or before so and so. 2 years of with effect from here. Further, UGC had again extended the scheme up to a year, which was conveyed to the college by so and so. The college stated that the construction has been completed on a year, which is beyond the stipulated date that is so and so. In this situation, no grant may be reimbursed at this stage as UGC guideline. That apart, the work order dated year issued in where does not speak about the total value that was awarded to the petitioner for construction of year. Now, how do you take care of this?
Lordship, this scheme, Lordship, that is from 2015, the UGC under the 12th plan, there was a continuous scheme till 2019. After that, it was extended till 2020. After that, the last date was 31/3/2020. So the order was allotted to this petitioner, Lordship, for completion of a building, Lordship, not for construction, Lordship. Lordship, may kindly see, Lordship, page 9, para 9, Lordship, of the repetition, Lordship.
Now, the problem arises because
Lordship,
of your college.
Lordship, already 14 lakhs you have given to the petitioner, Lordship.
That is not of a matter, taking into account that you had to give it what was to be, because you see, UGC is otherwise saying that we are not going to give it. You are saying that the amount will be paid to him. Your completion certificate is subsequent. Now, UGC is creating the problem.
Listen, Lordship, and Annexa 14 page, Annexa 2 page 14 of their petition only, Lordship, the work order, approximately 54 lakhs and time allotted for completion of work is 90 days. The said time period was granted to complete the work already done, not for phase construction, Lordship. Annexa 2 page 14, Lordship.
Anyways, you have filed the affidavit on 4/6.
But regarding the Lordship, UGC's affidavit, we'll file a reply, Lordship.
You file your reply. But
Yes,
you
Lordship.
file your reply. Madam,
Yes, sir.
Gogoi, you file your
Yeah,
affidavit. Next time, I don't want, we don't require your presence, but the fact remains that the matter has been pending before this court. And
Yes, my lord.
the delay has occasion on account of you not filing the affidavit. So next
Yes,
time
sir.
your counsel is seeking time to file the affidavit. So তেখেতে affidavit to file কৰে মানে আপোনালোকে সময় দিছো ফাইল এখন কৰি লগালগ ফাইল কৰি দিব।
Lordship,
তাৰপিছত আমি এইটো কৈছো।
and the present principal lordship, she joined the duty as principal on 11 January 2020.
That is immaterial. Whether the school or college was having a principal or not. We are not nothing to do with the principal. We are to do with the college. The college has granted the contract to the petitioner.
So we'll file it, Lord.
It is seen that in pursuance to the order passed by this court on 24/4/2026, Dr. Mosumi Gogoi, Principal
My
Think
lord.
is present to the video conferencing mode. Ms. B. Gogoi appears also on behalf of the Think College. This court has also been informed that the Think College have already filed an affidavit in opposition on 4/6/2026. Copy thereof have also been furnished to the petitioner. Would you like to file an affidavit? Reply. Ms. So-and-so, who appears on behalf of the petitioner, submits that the petitioner would file a reply. This court have also perused the affidavit filed by the Think College, as well as also heard Ms. Dr. Gogoi, the principal, who submits that the payment would be made to the petitioner upon receipt of funds from the UGC. However, the affidavit, it appears that the affidavit of the UGC have not been taken into consideration. Ms. B. Gogoi, appearing on behalf of the Think College, submits that a reply would also be filed to the affidavit filed by UGC. List this matter again on 22/7/2026. In the meantime, the affidavit in reply be filed by the petitioner on or before 15th of July 2026. The Think College, that is respond number 4, na?
Yes,
The respond number 4 shall file the reply to the affidavit filed by the respondent numbers 1 and 2 on or before 15th of July 2026. The personal the presence of so-and-so of the principal Think College is dispensed with.
May I please, Lordship? Lordship, this IA is filed for extension of some more time to comply the order, Lordship.
What order?
Order dated 8/9/2025. Here, Lordship, the objection was issued to pay the admitted amount, contract amount to the petitioner, Lordship, within 4 months.
My lord, the grounds they have taken in this IA lordship was already before this honorable court while disposing of this writ petition.
Huh?
My lord, the ground they have taken in this instant IA lordship was already before this honorable court before while disposing of the writ petition lordship. If your lordship may kindly allow me to read para 6 of the final order lordship. At page number 11 of the IA.
Wait. Para?
Para 6 and 7 lordship.
There's no 6 and 7 of the IA.
IA. Page 11 in the
Page
IA lordship.
11.
Page 11 of the IA.
The court was of Central
Lordship,
Silk Board, Lordship. And it was executed by Central PWD. Now Central Silk Board is not releasing the fund, Lordship. Therefore, the petitioner could not be provided the.
Lordship, this was already before this court, lordship, while disposing of the writ
Earlier
petition.
also submitted.
May I read
Lordship.
para 6, my lord.
Para 6.
Anyways, what do you want?
Some more time, Lordship, since.
When?
Lordship, during the pendency of this, I already 3 months has already been passed.
Yes, Lordship.
What are you going to do? You have been granted interest at 7.5%.
Yes, sir.
Then
Now,
are
Lordship,
you going to get 7.5% anywhere in the banks? Then? Yes, madam. When are you paying?
Because they are not releasing the fund lordship, therefore we are the Central Silk Board.
Huh?
Central Silk Board lordship, and Central Silk Board was not a party also, therefore
Central
Silk Board. Silk Board.
Silk Board.
Silk Board. The contract work was of Central Silk Board. It was executed by Central PWD. Now the Central Silk Board is not releasing the fund. Therefore, the CPWD lordship could not provide the payment lordship to the petitioner.
Then file a review to that order. Why you are filing this IA? Say that is the problem.
Lordship.
File a review to this order. The CPA has been pursuing the Central Silk Board for release of the fund. So you are not in a position because Central Silk Board
Yes,
was
lordship, they
waived.
are not releasing the
So
fund.
therefore you come up with an IA to that effect.
Right.
That seek a review to this order. You can't, why you are asking for extension then?
Because
We
communication
can't
is,
give you an extension
communication
unless
is
you
going
can
on,
commit.
lordship.
Can you give us commitment that you are going to pay within a particular period?
No, lordship. No,
To come up with a proper application, not this application.
lordship.
Withdraw with liberty.
Lordship.
Ms. So-and-so, the learned counsel appearing on behalf of the petitioner. Applicants submits that the applicants would be well advised to withdraw the instant application with liberty to file an appropriate application. So taking into account the above, the instant application stands closed on withdrawal. Liberty, however, is given to the applicants to file an appropriate application.
May it please your lordship. Lordship, this is connected with item number 60 of the daily cost list.
What it is?
This is an IA for
what?
impleadment, your lordship.
Implead whom?
Implead the present applicants in the pending writ petition, your lordship.
Whom do you want to implead?
The applicants here.
Huh?
We are the applicants. We want to get impleaded in the case. We have not been impleaded, your lordship.
You were not impleaded.
Not impleaded by the writ petitioners.
Who are you?
Lordship, the writ petitioner seeking possession of 3 shop rooms. Shop room number 2, 3, and 17.
Who is the petitioner?
And we actually the name of the petitioner.
Who appears for the petitioner?
Name is not shown in the court list, your
Huh?
lordship. Name is not reflected in the. But we have duly served it.
M. Datta.
Item 60 is there, my lord.
Yes.
This matter may be called with item 60 after some time, my lord.
60.
Because in 60 petitioner will come, my lord.
Yes, yes.
Wait for that.
Lordship,
Where is he?
He's on legs, lordship. Lordship, as per last order dated 11/5/26, lordship. District Commissioner Dhemaji was directed to apprise this court as to whether in continuation of various communications.
PNRD. The vouchers have been submitted on 22nd of May, on 23rd of December, 2024. Yeah.
My lord, lordship, I
Surprised
kindly-
as to whether in continuation to the various communications referred to in the affidavit filed by the respondent, certificates regarding the validity of the vouchers and OER have been submitted to the Commissionerate of PIA. We are now in the honor to submit here with the pending bills of so and so, so and so, so and so.
My lord, after 2024, we had already approached finance department. Finance department said, my lord, the authentication validity with validity certification is required, my lord. Thereafter, we have issued, my lord, on 2025 and also 2024 also to district commissioners, my lord, to issue the valid certificate, authenticated certificate, my lord.
We do one thing. It seems to be a problem between you and him.
Yes.
Both of you pay cost, interest on.
Lordship had disposed of a similar matter, Dilip Botra case, my lord. In that case also, my lord, the original bills were not there. And Lordship had directed to, from the photocopy, my lord, to send the district commissioner with authentication certificate, my lord.
Where that order?
I can give, my lord.
Anyways, we have it next week.
My lord. I'll place that order, my lord. Open up, yes.
List this matter on 19th of June 2026. In the meantime, this court pursuant to the order passed by this court on 11/5/2026, whereby instructions were sought from the District Commissioner Dhemaji as to whether in continuation of the various communication referred to by the respondent number 1 in the affidavit, the certificates regarding the validity of the bills and vouchers have been submitted to the Commissionerate of the PNRD. Mr. M. Sethi, the learned standing government advocate, has placed before this court an instruction dated 22/5/2026 issued by the election officer Dhemaji. How is this relevant? The BC has not done it. You see that no instructions. You see that no instructions have been provided by the District Commissioner Dhemaji. The said aspect is in flagrant violation. The said aspect appears to be non-adherence to the directions passed by this court on 11/5/2026. In that regard, this court therefore directs the District Commissioner Dhemaji to provide the instructions as sought for by the order dated 11/5/2026 on the next date so fixed in the instant proceedings without bail. List the matter again on 19/6/2026. Hello.
Mr. VK Singh, Lord. VK Singh. Lord, can it be taken on Thursday, Lord? Thursday, Lord. Lord, the order is covered by your Lordship judgment, Lord, the first case.
Anyway, it has been submitted that Mr. BK Singh, the learned standing counsel of the FCI, is busy in another court. Accordingly, list this matter again on 17th of June 2026.
The petitioners have other.
Any resolution to the dispute?
Yes, my lord, we carried out a survey, my lords. The report has also been furnished, my lords. Even the lands in the vicinity, my lord, they also belong to the petitioner. So even the lands in the vicinity of the land in question, they also belong to the same petitioners, a set of petitioners. So there is no question of relocation. It would probably boil down to compensation, my lords. I have a report from the.
So you take up as per that.
Yes. One issue perhaps, my lordship would need to. Works of licensee rules, my lords, yes. One issue that perhaps would require some determination, my lords. The erection of those lines, my lords, was not carried out by the APDCL on their own accord. This was with regard to providing electricity to a hospital at Sipsagar called the Sukafa Hospital, my lords. We were never part of the project as such, but we were roped in by the district administration. So we have written to the hospital also, my lords. If they would perhaps have to step in and for the bill.
It's connected to the hospital. Simple.
Lords,
They will pay that. What am I going to look into?
This is the report.
No, so therefore you are to take action. Now you see, the thing is like this. It is something, those provisions as per that Act of 2019.
19. Rules are of 2019.
The rules of 2019 which is being made is in consonance with the central rules.
Yes.
Now, you may have to take into account that who is being affected because your line goes.
Yes.
There's no quarrel, you have to take.
Yes.
But you can very well do it because that line is for the benefit of the year. Now, whether that hospital is a party.
No, hospital is not a party.
Yes, yes. So the respondent number 4.
Nobody appears.
You are there.
Yes.
Then you don't want the electricity, I suppose.
So twice they have taken time for filing affidavit. No. No. They have not approached. They have not approached.
Should I send it to mediation?
No, but also they have not approached before us.
Better off. You implore upon him.
But there is
Make the
actually a
payment to
letter.
him.
There's a letter also, my lord, we have placed, written to the hospital also, the APDCL, my lords. There's a letter of.
Understood.
Yes.
So therefore, taking into account that, let me send it to mediation. That is the best way out. And if the mediation works out, a memorandum of settlement is reached, whereby what compensation is there. But the problem will always arise, one thing, that on the basis of the mediation, whether you will have the right of way over the land of the petitioner without taking recourse to this use. Or you may have it, one thing, and it is the question of quantum.
Quantum, yes.
So if that is fixed up by the mediation, thereupon I think you may initiate those proceedings as per the rules and pay them the year they will be satisfied, and thereupon you proceed and take it over. I think that solves the problem, I suppose.
Yes.
The petitioners herein are aggrieved by the actions of the respondent APDCL in laying out what are laying out? Transmission lines over the land of the petitioners without following the due process. It is the case of the petitioners that on account of such line being taken, such transmission lines being laid over the lands of the petitioners, the rights of the petitioners under Article 300A of the Constitution have been violated. Mr. B. Chaudhary, the learned counsel who appears on behalf of the APDCL, submits that upon carrying out the survey, it has come to light that the transmission lines have been laid over the lands of the petitioner. He, however, submitted that the transmission lines had to be laid over the lands of the petitioner in order to supply electricity to the respondent number 4, which is a multi-speciality hospital. The learning council for the APDCL, standing council for the APDCL, also submitted that for the purpose of taking effective steps for redressal of the grievances of the petitioner, resort has to be taken in terms with the Assam
Works of Licensee Rules 2019.
This court also heard Mr. So-and-so, the learned counsel who appears on behalf of the respondent number 4, who submits that certain talks of compromise are going on as regards the compensation to be paid to the petitioners.
But Lordship,
They have not approached before.
His submission. That is not your submission. It is the opinion of this court that the resolution to the instant dispute lies upon arriving at a settlement as regards the compensation amount, and based on such settlement, the appeal authorities can be asked to proceed in terms with the rules of economic. Accordingly, this court directs the instant proceedings to be placed before the mediator for an effective resolution only as regards the extent of the compensation, and thereupon submit a report before this court. On the basis of such resolution, this court can pass further directions. First, the registry shall do the needful and inform the parties about the appointment of the mediator and first, list this matter again on 21 August 2026 for an appeal. Thank you.
Not as per
Yes,
last order, my lord, petitioner now filed, my lord.
Sure, as per the last order, the petitioner was given liberty to approach the BTC authorities as per the updated rates, lordship. And he has duly approached the authorities and we have sanctioned the amount, lordship.
My lord.
Page 3 is his revised bill, lordship.
The financial sanction has been granted. You can close.
My lord.
The petitioner herein has approached this court being aggrieved by the inaction on the part of the respondent authorities to make payment of his dues, of his outstanding dues for hiring of his vehicle, hiring of the vehicles of the petitioner. Mr. N.R. Sharma, the learned standing counsel of the BTC, submitted that pursuant to the order passed by this court on 12/12/2025, the petitioner had submitted a representation.
Revised bill, lordship. Revised bill, my lord.
Huh?
Revised bill as per PTC rate, my lord.
Had submitted, had approached the respondent authorities by submitting the bills as per the approved rate of the BTC.
Yes, ma'am.
In pursuance thereto, the financial sanction has already been granted to the petitioner. In that regard, the instructions dated 6/6/2026, along with the financial sanction order dated 6/6/2026, have been placed before this court, which is kept on record and marked with the letter X. From the state instructions as well as the financial sanctions, it is seen that an amount of rupees 4,68,000 have been sanctioned to be released to the petitioner. Mr. H.R. Ahmed, the learned counsel appearing on behalf of the petitioner, submits that in view of the said financial sanction being granted, the petitioner would be receiving the present amount, the petitioner would not like to further pursue the instant proceedings. Accordingly, this court closes the instant petition with a direction to the respondent authorities that in pursuance to the financial sanction being granted, the said amount be disbursed to the petitioner within a period of 15 days from the date of the present order.
Met with the lordship. Petitioner before lordship challenging the settlement order in respect number 5, my lord.
Okay.
And there is a specific direction by order dated 4/3/2024.
What is that?
Serial number 7, my lord, order.
What is your case?
My lord, the respond number 1, 2,
It
and
has to be
3.
listed on 4/6/2026. Why it didn't come? Why it has come up before me today?
No, I'm.
Today is 4.
Eight.
Today is 4.
8. Matter is not found.
What is your case?
My case is, my lord, there is a specific direction by order dated 4/3/2024. Serial number 7, my lord. Respondent number 1, 2, and 3 shall also conduct a preliminary inquiry with regards to the allegation made by the petitioner. So whether the inquiry or whether we are not,
This matter.
they even did not file affidavit. My case is that, my lord, I am challenging, we are in a Gyan Gaurav Min Palon Cooperative Society, my lord, challenging settlement order to respond number 5, my lord. And only ground that, my lord, there is a, my lord, condition of the NIT, my lord.
Mr. Mohanto, why the matter has been listed today? Mr. Mohanto is not ready today to do the matter, obviously. The matter is.
This case, my lord, their order, which was my learned friend shows, that was the expertise order. Because that order, my lord, earlier round, my lord, earlier round of petition filed by another persons, my lord, that is, my lord, petition dismiss, writ appeal dismiss, SLP dismiss. The same question, my lord. Is it?
Who is Ghanadhar Das?
We are, my lord, I am the tenderer, my lord, one of the tender. I am the third highest bidder, my lord. Second bidder.
Who is Ghanadhar Das?
He is in the cooperative society, Kumotria Group Fishery Cooperative Society. He is one of the member and he is the defaulter, their own, my lord, problem, my lord. Now, I am coming, my lord, because of that, I am the third highest bidder, my lord, and second is not willing to take this, and thereby we file.
No, my question is,
my lord.
Mr. Monto did the other side in the case of Dhanodas.
My lord.
Whether the question, the allegations which have been raised by the petitioner in the instant proceeding have been duly taken note of.
Yes, ma'am. Your lordship kindly see, my lord, his case is that, my lord.
Okay, then tell me, what are the allegations of the petitioner?
Allegation that, my lord, that Dhanodas and Nabodas same man. No, sorry, Nabodas and Devodas same man. So he's Nabodas, he's a member of another society, so he's not entitled to get any settlement. So then it was challenged by Dhanodas in earlier number of petition. Dhanodas, and then by learned Singhaldar says that it is a disputed question of fact. In 2 ground petition was dismissed. One, that Dhanodas was the earlier lessee. He did not participate in the tender process. He said he is paying for extension. And second ground is that there is a Devodas and Nabodas same man, so he's not entitled to get settled. So in these 2 questions, my lord, the question, my lord, negated, my lord, this question dismissed. Then finally retake. A DTP order I placed before your lord. And para 4 and 5 of the DTP, para 4 and 5. 4 and 5.
Private document produced from the court by the party. You know, where the find of the document is given.
SLP for order to ask. Order to ask.
Cancel for illegal property. Okay, so these are the 2 grounds.
My lord, then against that they went to Supreme Court. Supreme Court dismissed it, my lord, that order is placed before your lordship.
That is different. Now, what is your allegation, Mr. Counsel?
My allegation, please may kindly see it. I'm satisfied.
This petition was filed after 2 years of the settlement. Settlement was 2023, it was 22, my lord.
You have fenced it?
No, my lord.
After 2 years, my lord, that was finished.
My lord, I have so many, my lord. I am the last person I'm going to the police station. Police station also verification is, police verification is also there. Report is also there annex. Thereby, my lord, I am
Now,
going.
what is your allegation?
My allegation that, my lord, as per condition of that NIT, my lord, and page 43, my lord, 2.209, if the bidder is a defaulter to the cooperation, his her tender will never be considered accepted. Next, 2.10, no member of a cooperative society will be able to submit tender personally or individual capacity if it is proved that the bidder is a member of the cooperative society, his her tender will be rejected.
It's okay. These
Because of that, he is the cooperative.
Mr. Bora, these are conditions.
Condition.
Now, come to the facts.
Yeah, come to the facts, my lord. What happened, my lord? Is the Nobod, these cooperative societies, he name entered as a Devodas.
Again, same thing.
Yes, my lord. And no. But one thing is that, my lord, that was the number one, my lord. And secondly, my lord, entire all my lord, my lord, and voter list, so all name was there is in
But
Devodas.
therefore, the question is, the court said that it will be disputed. No, Mr. Bora. The court said, the coordinate bench said on this issue, the 2 points the division, the coordinate bench held it. One, and he is not a tenderer.
He is not tenderer.
One. And the second is, whether this person is Devodas or Nobodas is the same person, cannot be adjudicated in a writ proceedings.
My lord. But if he is a member of that particular society, by putting his name as a Devodas and other all document as well as all election, high card, voter card, everything is there. When this matter question is came, they go to, they say that no, I am the same person. So definitely he's a man, my lord, as a Devodas, my lord. He is a defaulter as a society, and defaulter society, your lordship, last page of the,
but
they did not pay even government.
This court, the coordinate bench have held it. That you see, this is a Devodas and Nobodas, whatever it may be, these are questions of facts. We 226, we won't look.
Same one of the coordinate bench directed to the inquiry. Which are good.
That there is a difference.
My lord.
Coordinate bench directed as an interim.
My lord. But
whereas that order passed by the coordinate bench in case of Ghonodas is a final order.
Final order, I am not in that proceeding, and on
You
the
are-
other, he is
you are not.
No, he is the not locus tender because he is the not a tender. And he specifically.
No, that is the second issue.
My lord.
That is the second issue.
My lord.
Then why did you come after 2 years?
2 years, that means, my lord, we
Did
are.
you wait for the case of Ghonodas to be over?
2023 representation before the my lord authority, my lord, number 1/8/2023, 28/11/2000. Thereafter, last they did not do, we file an FIR. And FIR, there is a verification, there is a report, my lord. There is a report.
No, understood,
Page
but how can you
77.
change this? Why should we entertain 226? No, very difficult.
But one
You
thing is
missed
that
your
if
bus.
I missed the bus, but I am.
Now, these societies are under the cooperative department.
My lord?
Is it under the corporation department?
Yes.
These cooperative society, these are cooperative societies.
No, I am the cooperative society.
And that Devoda Sudhya is a cooperative society.
Cooperative society is fine. I am not an individual. He is a member of the cooperative, one of the cooperatives. He is a defaulter. They did not pay. And so his names, since 2 names are there. One name is there, that society. He did not do it. And another name is he going to file a tender process, participating in the tender process, my lord. After all, and for this going to, my lord, doing by if you want to look at all documents, your lordship go to the even voter card, his wife also say as a Devodas wife voter card.
Is there in my next, my lord.
Understood, but the problem lies with the courted bench holding it.
2 point is there, my lord. That coordinate based, my lord, he is not a tender. I am the tender, I have the right, my lord.
No, the question is whether Devodas or Nobodas is a question of fact which this court should not entertain.
If the all records are is reveals that their office government of records are revealed that the Nobodas is the Nobodas and Devodas is the same person, then honorable court have to, my lord, consider it, my lord.
You see, the same. Mr. Chaudhary, by drawing attention to the extract of the voters list of Pumotia so-and-so annexed as annexure 3 has contacted Devodas and son of Horendas. So-and-so is a member of the ER. It is contended that so-and-so. Projected that one of Horendas had 4 sons, so-and-so. With such projection, so-and-so has contended that prayers made on behalf of the petitioner in the present petition are to be allowed. Further referred to other documents annexed to the pleading to buttress it has contended that response number 2 can very well examine and determine the aspect about the act of impersonation committed by Devodas as well as Nebodas in getting the plan. In response, P. Sharma, Mr. Mohanto. Mr. Mohanto, you've been there from beginning.
Yes, my lord, I have all my annexes are there, my lord. Even he is not given reply to my affidavit, my lord. I have given my Aadhaar card, my SSLC mark card, my
Presence reference may be made
My
to
birth
the
certificate.
contention of the AR regarding so and so. It alluded that the Horendas are resident at 4 sons, Devodas, Nobodas, Ranjitas, Sagodas, Vivadas. Same allegation was made in that that Devondas and Nobodas are where one of the same person. In the minutes of the meeting of so and so, the same kind of claim regarding officer was made. The affidavit replied the petitioner has annexed so and so. So and so, in reply to the petitioner contention regarding even a certificate dated from a ward member. So and so, certificate dated of the executive member. Certificate of one former president, so and so have been annexed. A rebuttal to the there, respondent number 6 has submitted a certificate of birth, an admit card, Aadhaar card, so and so, the core issue which has fallen. Very
My
difficult.
learned friend also not my lord senior, but that affidavit not disclosed and not given in the reply. What about the 93 voter list? They did not reply even 2024 voter list. Why they did not reply?
Mr. Bora, the voter list business is for
But
that foreigners tribunal bench, not.
but entire is it taken by fraud and
Mr.
manipulated
Bora,
by
very
this?
difficult. I think you should have got the matter done on 4/6 itself. Anyway, it's a Monday matter. We finish it off now. Can't help you. Heard Mr. N. Bora, the learned counsel, appearing on behalf of the petitioner. Mr. T.J. Mohanto, the learned senior counsel, assisted by Ms. P. Bhattacharjee, appears on behalf of the respondent number 5. Mr. P. Sharma appears on behalf of the respondent number appears on behalf of the AFDC. The petitioner herein, who had submitted its bid pursuant to the notice inviting tender dated 14/3/2022, being agreed by the settlement granted to the respondent number 5, have approached this court by filing the present petition. The basic contention on which the petitioner the basic contention on which the petitioner's case hinges is that the respondent number 5 is a member of a cooperative society in the name and style of Pumotia Kumutia Group Fishery. Huh? Isn't it?
Kumotia Group Fishery.
He's a member of Kumutia Group Fishery. No. No. What is this? What is the name? He's a member of which
Gyan Gaurav Mean Palan Cooperative Society.
Huh?
I know. I'm just sick.
Name, where do I find that? No. Kumutia Group Fishery Samavai Samiti Limited. Is a shareholder of Kumutia Group Fishery Samavai Samiti Limited. And as the said society is a defaulter, where's the term?
Period for 7 years, minor.
And
22.
And as such, in terms with clause 2.9 and 2.10 of the tender notice, the respondent number 5 could not have participated in the said tender process. It is the further contention of the petitioner that the respondent number 5, though, have been granted the contract, have been allowed to participate in the said settlement process in the name of Sri Nobokumar Das. But actually, his name is Debokumar Das and a member of his society, Kumutia
Group
Society.
Fishery Cooperative Society.
Huh?
Kumotia Group Fishery Cooperative Society Limited.
This court duly takes note of that the settlement was made in favor of the respondent number 5 by an order dated 9/6/2022. The petitioner approached this court by filing the present writ petition on 13/2/2024, alleging inter alia that the person, that respondent number 5, alleging inter alia that Nobokumar Das and that alleging inter alia that the name Nobokumar Das and Debokumar Das belongs to a single person, same person. And as such, there is a violation of clause 2.9 and 2.10 of the tender conditions to grant the contract in favor of Sri Nobokumar Das. That is the respondent number 5. It is very pertinent at this stage to observe that during this period from 9/6/2022 till 13/2/2024, when the petitioner approached this court by filing the present writ petition, another writ petition was filed by a person, namely Sri Ghonodas, who was the president of the Kumutia Group Fishery Cooperative Society Limited. At the cost of repetition, this court observes that it is the allegation of the writ petitioner in the present proceedings that Nobokuma Das is a member in Kumutia Group Fishery Cooperative Society Limited and have used the name Debokumar Das. He says, why he is with Debodas or Debokumar Das?
Page 59.
Debodas. Have used the name Debodas. Next. The writ petition which was filed by the said Honodas, however, was dismissed, which filed by the said Honodas, being registered as WPC number 7442/2022, was however dismissed by the learned coordinate bench of this court by a detailed judgment and order dated 26/9/2023. There were two grounds on which the writ petition was dismissed on being not entertained. First, that the said Ghonodas was not a tenderer to the said tender notice dated so and so. The second reason, which assumes prominence in the present proceedings, is that the learned coordinate bench of this court categorically observed that as to whether a single person have used the word names Nobokumar Das or Debodas is a question of fact which cannot be adjudicated in a writ proceedings. This judgment was pronounced on 26/9/2023. The question therefore arises in the instant proceeding that in respect to the same issue which is being raised by the petitioner with certain more better particulars, should this court exercise jurisdiction under Article 2 to 6 of the Constitution? This court also have taken note of the affidavit in opposition filed by the respondent number 5, wherein various documents have also been enclosed, such as a certificate of birth issued on 12/3/2007 by the Register of Births and Death Director of Health Services, Government of Assam, semicolon, an admit card issued by the Board of Secondary Education, Assam, for the purpose of appearing in the high school leaving certificate bracket compartmental examination 1997. Semicolon, an Aadhaar card dated 24/1/2020, as well as an extract of the voters list published in respect of village part 2, Bibelia Coimbatore under Dhemaji Scheduled Tribe LAC, to repeal the contention of impersonation and establish the existence of a person, namely Nabakumar Das, son of Horen Das, separate from Debo Das. This court, having taken note of the judgment passed by the learned coordinate bench dated 26/9/2023, and this very aspect having also been upheld by the learned division bench of the court by an order dated 5/4/2024, in writ appeal number 20/2024. It is the opinion of this court that judicial discipline demands that this court should not further entertain the instant proceedings. Accordingly, this court therefore dismisses the instant petition on the ground that it is on not being entertained. Liberty, however, is given to the petitioner to approach the appropriate forum, if so advised. The period of pendency of the instant petition, that is from 13/2/2024 deal date, be excluded while computing the period of limitation. You should go to the civil court.
Right.
'27 got postponed to '28, the holiday.
Hello. We have to fix this on another day.
My lord, can give me a Thursday, my lord. Fixed at 2, my lord.
When do you want it?
This Thursday, my lord. I'll convey this to the senior counsel appearing for the municipal court.
Not possible.
Not possible, man.
Not
Next,
possible this Thursday already 17 matters, next Thursday 15 matters. We
Tuesday,
can have it on Tuesday,
yes,
on 16th.
16th. 16th of, my lord, the council appearing for municipal.
We'll have it on 16th.
16th of June. 16th of
List this matter again on 16th of June 2026. Okay. For final disposal.
You lordship has fixed it on
16th
of June for final.
Can it be 23rd. 23rd is one matter I have now. But the problem lies there is 23rd, 22nd to 26th would be a motion.
All
Okay.
right, 16, all right. Then I'll try.
My lord, 16.
If there is any problem, my lord, the lordship will acknowledge. My lord, as
I've
of,
already heard the matter.
yes, many times. Okay.
As of now, my lord, can it be at 2 o'clock?
Yes. Okay.
Wait, please, your lordship.
Yes.
My lord, at the very beginning, I solicit a permission from your lordship to take the assistance of my juniors, Milan, as I have got a serious vision problem, I could not read properly. So I will speak the factual parts, Milan, whenever it is necessary for reading some of the documents, Milan. Your lordship may permit my juniors to read about it, Milan. With a deep respect.
Did you get a stay?
But my
Did you get a stay in the instant proceeding? Status quo shall be maintained till the next day.
the status is it is vacated on 1/4/2025, Milan.
Then what remains?
No, it stays vacated, Milan.
Then what remains? Your basic, you have not been able to participate in the tender process.
No, Milan, because not on our fault, Milan. If your lordship goes to the order passed by this honorable court on 1/4/2025.
Now, what happened to the tender, madam? Who is paying for this? Respondent.
His tender was not in the GM. His tender bid was not in the CEM portal, lordship, therefore he would not be considered this.
That is the one thing. My question is, what happened after vacating the stay?
Now, the qualified lordship tender has been implemented.
Huh? People have been empaneled.
Well, we have grounds for that, Milan. May I request your lordship to hear my reading of this 1/4/2025 order, Milan? That will clarify the position.
Now, this empanelment is done once in a lifetime or what?
No, so it is 3 years per period, Milan.
3
But that
years.
is only
Now
for
3
3
years, almost 2 years have gone. 1 year is left. By next year, you can participate.
No, my lord, it was not on our fault, my lord. The fault has been with the
Mr.
respondents.
Gopatragoy, I understand everything, but the fact remains today the matter has become infructuous.
No, not
Now,
that way, my lord.
allowing you to submit in certain documents, allowing you to submit documents of drug license valid up
My
to
lord,
31/12/2026.
My lord, I'm submitting before your lordship. The drag license that was issued by the competent authority is valid up to 31st of December 2026, my lord. And they have said that as because it is not digitally provided, they have not uploaded that. But subsequently, my lord, we have approached the drug licensing authority. They have said that in Assam, the digital process has not yet started. That is why as because it is valid up to 31st December 2026, my lord, that will work. And in the initial stage, my lord, when we have submitted documents because they have said that it cannot be uploaded. But after 6 months, 11 days, on 25/5/2025, my lord, the GEM has made us a request on 1st of May, 2025. And on that basis, we have sent the same set of documents wherein all the documents were there, and they have accepted the same set of documents after six months and 11 days, my lord. That is why, my lord, we have a case for that to be decided by your lordship on that matter. Even in GEM's reply, my lord, they have also admitted to that extent.
Where is the affidavit of the respondent? Yes, where's your statement in your affidavit?
In yes, 88 Lordship. Para start from para 7, it is from 86. So Taylor. Para 7, page 87, 86. Mend.
Mr. Bopatogu, have you filed a reply?
Yeah, yes, Milord. We have the fine reply, Milord.
Relevant is page 88.
Where is your reply?
One of the ours is at page 169. The last reply we have filed before, not so. This is CGS's reply, Milord. Cut out the CGS.
Now, why you say that it is not your fault?
It is not my fault because the same set of documents, Milord, which they did not upload. After 6 months, because, my lord, 6 months, they have uploaded it. And after 6 months of our process, when on 8th of November, that was closed down, my lord, and there was a procedure in the tender system that immediately on the next day, they have to report that they could not upload it. We have done it, my lord, they have refused it. And thereafter, my lord, as because the James have made a statement on 1st of May 2025, my lord, requesting the law manager requested the petitioner to submit the relevant documents on online basis, email basis. And the same set of documents as we are having, and also our license is valid up to 31st of December 2026. We have sent it. And on 8th of May 2025, on 25/5/2025, they have approved the same set of documents. That is why I'm saying, Milan, that it is not our fault. It is the fault on the part of the CGSC and on the part of the GEM. And in their affidavit, Milan, they have admitted to that action.
Page 88 Lordship.
Now this, let us see the tender process, tender. They've enclosed the tender, no way.
Yes, sir. The tender process is started on
Where the
4/10.
tender, OPD, page 129.
Yes, sir.
Where is the requirement as per the tender document of this drug license?
Yes. Minute page 23. Okay.
Eight.
Point number 6. Point number 20. Page 24, minute at point number 6.
Okay, now here it says the drag license so and so should be valid on the date of submission.
Minor, that is valid because in 21 on 30th of July 21 million, the tender, our tender was accepted and we were allotted the supply work till the 31st of December 2024. In that document, Milord, there is a clause 12, Milord, which has been changed to clause 8 in the 410 tender notice, Milord. The clause is that the under no circumstances the extension will be made, but if the additional director is satisfied with the performance, satisfactory performance, then he may extend for one year, Milord. We have made an application under that. That was not disposed until ultimately we had to approach this honorable court by a writ petition number 4294 of 2024, Milord. And there, Milord, there was a direction, and speaking of, there is a direction of this honorable court on 8/10/2024, Milord, to dispose of the representation pending. Representation was made on 23rd of September 2024, Milord, well ahead of the time. And a speaking order was to be passed. When the speaking order was passed, Milord, it has not been followed the procedure of law, because of which we again have to approach this honorable court by another writ petition number 5441 of 2024, Milord. And the direction was passed in that to issue notice, and that is continuing, Milord. And if your lordship comes to the order of this honorable court on 1
No, whether your license was valid.
License is still valid, Milord.
No, was it valid as on 4/10/2024 or
Yes,
for that
yes.
matter, the date of submission of the bid
Yes, Milord.
on
It was valid, Milord. It is still valid.
date of
Milord. Same-
beginning of the bid date and bid of the date of submission of the bid is?
Yes, Milord. It is
Bid
still
end
valid,
date,
Milord. That same
1/11/2024.
Yes, Milord.
1/11/2024, you had a valid date.
Valid.
Now you did not submit that document.
No, we have submitted the document that was in the physical form, Milord, and they have suddenly instructed that it is to be submitted in digital form. we have approached the state government drug licensing authority. They have said that as your license is valid up to 31st of December 2026, there is no requirement, and in the state of Assam, the digitalization process has not yet started. We have already reported to that GEM as well as to the CGSC, Millard, and
No, no,
thereafter.
that is the fault of the state government. I'm not concerned whether
Yes, sir.
they give or not.
Yes, sir.
My question is, as per the tender document, was it required for you to submit the bid, the drug license at the time of submission of your bid?
Yes, that was, we have already submitted, Millard.
You did not upload it.
No, we have uploaded, Millard, but was
We are drug person that was not accepted by the GEM. Your lordship may kindly see page 56 of the petition.
Yes.
Yes, in the door portion, it is stated that the upload certificate is expired, kindly upload the renewed certificate. But this certificate is extended to 2026. The GEM, they have not accepted and they have not cleared our catalog matter. And thereafter we have.
Where's your drug license?
Present is at page. Page 73 minutes. Or 73 minutes. Valid petition minute.
What is the number?
Sorry, madam, not in an additional affidavit dated 28/11, filed it on 28/11/2024, page from page 63 to 69, madam. Our additional application there as part of honorable court's order, we have submitted all our certificates, madam. Our drug license is at page 71. 71, 72, 73, and 74. Along with this, madam, we have submitted the other documents also. We have uploaded it, only this was not accepted by GEM.
The uploaded certificate is expired.
Yes.
Okay. Kindly upload renewed certificate.
Thereafter also we uploaded.
So you mean to say this particular document was shown to have expired on, it is categorically mentioned as 31/12/2026. Yes, madam. Kindly come to page 56. Down below. KMP 10-120-99 and KMP 121, expiry 31/12/2026. You mention it. How it is, if you are mentioning it as 31/12/2026, how do you say that the uploaded had expired?
Also, in our activity, it is stated that after the bid documents are uploaded in the GM portal, lordship, only after that we can work on it, lordship. Here, these are not even uploaded in the GM portal. lordship.
How did this happen?
So, may kindly see our page 88. lordship.
Understood, but how did this happen? Here, this document says the uploaded certificate is expired. Kindly upload renewed certificate. This is done by the GEM portal. Understood. So GEM had made the mistake. GEM had made the mistake. So therefore, how can the petitioner here be penalized?
until it is uploaded in the same portal, Lordship.
This is uploaded.
No, Lordship, can you see the page 88, Lordship?
Page
88 of our application.
Yes.
By the GEM authority and under the exclusive domain of the GEM portal, and respondent number 4 is not even remotely connected or concerned with this matter. The GEM portal has the sole authority to allow or disallow uploading of these documents by a bidder, and respondent number 4 has no role in it. It is only when a bidder successfully uploads his bids documents, and only when the earmarked time for opening of technical bid arrives, then only the GEM portal allows respondent number 4 to open the technical bid. Respondent number 4 has a very specified and limited access to GEM portal basis only to float NIPs, to fix date and time for submission of bids, to fix date and time for opening of technical and financial bids, etc. Therefore, the question of
So you put the blame, you therefore put the blame on GEM.
GEM. Yes,
Okay.
Therefore,
Now, wait. Now, GEM has its own rules. If I remember correctly, GEM has its own rules. You are to protect the GEM. You have taken a portal, the GEM portal. GEM portal makes a mistake. That's your mistake.
No, that's it. Only 3 bidders in the GEM portal, only 3 bidders have uploaded their bids, and their
Understood. The GEM have said that it is an expired document.
unless they uploaded the documents in the GEM Lordship, the respondent health department cannot consider their bid Lordship. Offline is not acceptable.
Understood. But the GEM in page 56 categorically says that it is expired document. It could not have been expired when you are putting the date of the document as on 31/12/2026.
Is the GEM to say why they have rejected?
Yes, GEM. You see? GEM says that. So therefore your entire thing is bad. You set aside.
But they have rejected it. On what basis they have?
We are not concerned. Doesn't GEM have a set of rules? Wherein it says that if any case is filed against GEM, who is to protect the GEM?
And they have a specific vendor agency which who verifies the document. So it's just a marketplace. They upload it. So if they start, we can do it. Or if the
Not sure, unless
And your affidavit starts with what? Complaints against petitioner. Yes. See, what are the documents you have enclosed? Copies of complaint letters against the petitioner found.
they claim that
Annexer AC. Meaning,
they
you
claim that-
start your affidavit saying that there are complaints against the petitioner.
No, Lordship, they claim that there is a satisfactory service, Lordship, against this.
Yeah.
In reply to this, Lordship, these documents were.
Therefore, doesn't it show that you have an intention to blacklist them and therefore not allow it? Yes.
Because unless it is uploaded in GEM, how can the Lordship, the health department can consider these bid documents, Lordship? It is not only 3, the Lordship, the bids documents.
Now give us a solution. What to do?
Already, Lordship.
Okay, you pay compensation. Pay compensation to the petitioner.
Lordship, it is GEM has Lordship. Rejected.
GEM is no, GEM is you.
No.
Yes. Tomorrow you come up out here and say that, okay, somebody allows you to use the marketplace. And you say that the marketplace is wrong. And therefore you blame the marketplace.
It is the Lordship.
Your affidavit is not convincing.
Departments. Lordship, on
Chalo.
the
Is
last.
this matter on 16/6/2026 at 10:30 AM for final disposal.
In this case,
This matter relates to non-payment of contractor's liability matter.
Of which department?
Irrigation.
water resource,
Your
water resource department.
water
Irrigation department.
What is your stand?
My lord, we have not received our instruction as yet, but they should meet the Union of India a party here.
Huh?
Properties, my lord, Union of India is not a party here. So for proper, it is under the flood management program. So Union of India should be a party, my lord.
No, my lord, there is nothing such as such. If your lordship sees the, my lord, their admission statement, my lord, page 36.
That admission is, my lord, given by executive engineer, which, my lord, there is a specific.
And the
instruction
work
by
orders,
engineer.
work orders were issued by the office of the executive engineer, my lord.
Executive engineers are not supposed to give this admitted liability certificates. No.
So, Mr. Rahul, you don't want to impede the Ministry of Jal Shakti, but you want to, but how are you going to get your contempt finalized? Problem lies there. Water resource, their basic plea is there, not to pay. Isn't it, madam?
My lord,
Water resource basic plea is not to pay is Ministry of Jal Shakti.
because we receive funds from them.
See,
Until we get to know that
My lord.
what is their stand of the central government and Jal Shakti. Brahmaputra
Mr. G. Rahul, the learned counsel appearing on behalf of the petitioner submits that in view of the submission made by Ms. P. Chakraborty, the standing counsel of the Water Resource Department, that the funds in the instant in respect to the work carried out by the petitioner comes under
Ministry of Jal Shakti,
no,
FNP, flood management project.
flood management project, which is a centrally sponsored project, comma. The petitioner would be well advised to file an appropriate application for impediment of the Ministry of Jal Shakti as well as the Brahmaputra Board
Yes, my lord.
as parties to the instant proceedings. This matter upon such application is filed.
52 also, my lord, same order. If-
Pleadings complete, my lord, let it come. They are claiming, my lord, under ROP 2017. Our stand is clear, my lord. that
We were
From
given
their
for-
own resource, they can pay, but not from the state.
We were given for 2.5 years and then thereafter without notice, it was reduced to 6 becomes. Pleadings are-
Mr. Goswami, there is a big problem which your case is at the time of issuance of notice only I said that because tomorrow here they categorically say that the ROP is applicable to so and so. That is the thing.
No, my lord, we are not an enterprise, my lord. We have explained our affidavit in reply. my lord. We don't come under that and we are not in that list. We have not been listed. They have given a list. That
No,
list is-
no, are you there in clause 2 of the rule 2 of the rules, ROP rules?
No, my lord,
If you are there, you get it. If you are not there, you don't get it. Like the Gauhati High Court, they won't get it. Assam Judicial
No,
Services,
here-
they don't get it.
My lord, here in this case, my lord, by a specific, my lord, list of uh, entities, my lord, which they call enterprises, my lord. They have ruled out the application of and they are.
No. That is different, but you have to see this particular kindly see here. This is applicable to whom? Categorically mentioned out there. Not the resolution, rules from goods. No. Rules for- the resolution, rules for goods, rules for- Economic payments.
কোন এখন লিস্ট এখন দিছে তো লিস্ট খন তো নাই
305. Yeah. Unless specifically extended under express orders of the government, these rules shall not apply to members of All India Services, members of the Assam Judicial Service, members of services to whom the University Grants Commission, so and so office of and staff of public undertakings of the Assam government. This is public undertaking.
We are a statutory board. We are a statutory.
So it would not unless there is an order of the government. It won't. That is your problem with T2B Roman 6. Like in Gauhati High Court, these people get it because there is an order of the government. Anyways, why should we, after coming after 2 weeks to dismiss a petition? Have it after
On a
vacation.
hearing them.
After vacation.
Why not after?
The pleadings being complete. List this matter on 21/7/2026. On which date an attempt shall be made to dispose of the petition.
Much obliged.
Is your lordship. Here, my lord. So.
You file a affidavit? Where?
Today, my lord. We need some time to file
Mr.
our.
N. Bora, the Learned Standing Council of the PNRD submits that an affidavit has been filed by the PNRD department. Mr. S. P. Chaudhary, the Learned Counsel for the petitioner submits the petitioner will file a reply. Early, when?
2 weeks, my lord.
Matter would become infructuous on 30th.
Otherwise, on 30th of June, it will become infructuous.
Then what remains? Why you are filing an affidavit?
My lord, because according
Okay,
to
let us. Then
the stand of the.
after the petition is over, then it's infructious.
But, my lord, the.
It's defective because we quoted more than 10% as per. report.
48. 47.1.
So far as private respondent is concerned, my lord, he did not.
Paid an
fulfill
amount
any of the
ten
criteria.
percent of the average. It is the opinion the said aspect be brought on, the said affidavit be filed on so and so. Chalo. Okay, list this matter again on 22nd of June 2026. In the meantime, liberty given to the petitioner to file reply.
This is lordship by order dated, by order dated 26 to 2020. Your lordship is directed to file an additional affidavit to correlate the petitioner with one Mr. Dinesh Shona, whom the petitioner claims to be her uncle, Miller. In this regard, we have filed an additional affidavit, Miller, and filed the final NRC.
You filed the additional affidavit?
Additional affidavit.
They filed reply? Why? Affidavit in opposition filed by respondent number 1. Who are you?
And the Social Justice Department.
Social Justice. You are the main people.
The committee who examined the.
Respondent number 1 has filed the affidavit.
But after this, we have not filed.
Rejoined by the petitioner, additional affidavit by the petitioner. So we need to
Those documents to release.
take up, huh?
Lordship wanted them to produce those documents.
They file an additional affidavit. So we do one thing, we have it after vacation for final disposal. Or before vacation.
Vacation.
Okay. At the request of the also taking into account that the matter requires an early disposal, list this matter on 18th of June 2026, on which date an attempt shall be made to dispose of the.
Here, the primary grievance of the petitioner was that the appeal under the Public Procurement Act had not been disposed of. So in the last
I've got
occasion,
the instruction by Friday, it will be passed, my lord. They've got, hearing is concluded, my lord. They've got a report from the DME. By Friday, it will be passed.
Mr. B. Gogoi, the learned additional advocate general, submits by 12th of June 2026, the order would be passed in the first appeal filed by the petitioner. So taking into account the above, list this matter on 17th of June 2026 for an update.
So in this case, the affidavit of the respondent number 7 is lordship most necessary because the forest department, they will remain silent on the part of the Miadi Patta land, which is the adjacent land of the petitioner.
They're reserve forest.
Inside reserve.
You disconnect everything. Have you seen the A. John Kennedy judgment? The recent one. Everybody's electricity should be disconnected forthwith. No PTS, nothing.
Only my humble submission.
We forget about you. How can we direct our electricity connection to you? Have you seen the judgment?
Yes, I have seen lordship. Only the
Which judgment?
lordship, that judgment
In your pocket?
lordship, I have not gone through entire judgment, but some part of the judgment I have.
What was the case about?
Lordship, if the land is covered under the thick forest, then also it can be considered as a forest. Lordship, some part of, I think the judgment referred in PT Godavarman.
Yes, Mr. Sharma.
The judgment.
You give him, Mr. D. Gogoi. Give him A. John Kennedy. It was given on 29th of May 2026.
Lordship, I have.
You're referring to the 97-2 SCC judgment.
Lordship, this one, yeah. Lordship, only my humble submission before this honorable court is that, Lordship, since the respondent, both the respondent authorities were remain silent on the point of that number.
Forest, Mr. Gogoi, if it is in reserve forest, the question of electricity, everybody should be disconnected. You should take up initiative because you have given an undertaking before the Supreme Court in Abdul Khalek that you will form a committee and look into this.
We found out 10 connections from the affidavit.
No, these connections should be also, you give them notices for eviction. Otherwise, it is very difficult. After all, reserve forest, you have to keep maintaining. And he has constructed and I can't pass it on.
Lordship, only my humble submission before this honorable court is that since they are remain silent on the point of Lordship doc number 764, where the petitioner has resided and applied for 2 times, Lordship, for Miadi Patta. And according to the Lordship.
How can a Miadi Patta be granted to you?
Lordship, because his land has been recorded under doc number 764, which is reflected in the Assam Land Revenue Portal, Lordship. Unless and until his name will not be reflected against the doc number, he cannot apply for under the Bosumdara. The first point is that. The second point is that, Lordship, the land which is adjacent to the petitioner, Lordship, that land was occupied by the Lordship Krishna Guru Ashram. That was a Miadi Patta land, Lordship. And the public, Lordship, they have, Lordship, also relied on the notification. As per the notification, Lordship, boundary pillar, Lordship, separation of the and partition of the boundary pillar through the boundary pillar that is marked with a PWD.
Leaving all aside, let us go through his pleadings, my lord. Any document he has just annexed a sale document, my lord.
Only my humble submission before this honorable court that only the deputy commissioner who is the Lordship revenue authority, and he can file the Lordship affidavit, Lordship, that whether that land is fall under within the Lordship doc number 764 or not. because the revenue authority, they has came to my house and Lordship, they have instructed me to provide the Lordship documents which are related to before 2019, Lordship.
For the purpose of?
Lordship, they have visited my house and collected the documents from me, Lordship.
For what?
Lordship, maybe pertains to this matter, but Lordship, they have not disclosed anything more, Lordship, except that. Lordship, because
Yes,
they,
yes, why haven't you filed the affidavit? You filed it. When? The electricity have filed it.
Yes.
And forest?
Forest also filed, my lord.
You have filed?
Filed. Forest one.
Respond number 2 and 3.
only
Who is forest?
Forest is my lord, respondent 6.
2 and 3 has filed it. You have filed when? 29/4. Or additional affidavit has been filed. Pursuant to our order passed by on 29/4. Okay. Mr. D. Gogoi, appearing on behalf of the Forest Department, submits that an affidavit has been filed on behalf of the Forest Department. And Mr. B. Das submits that the affidavit as sought for by the order dated 29/4/2026 have also been filed. The same, however, is not on record. List this matter again on 19th of June 2026. In the meantime, the respondents, thus registry, shall bring on record the said affidavits. Liberty given to the petitioner to file reply to those affidavits on or before 18th of June 2026.
Lordship, affidavit of the respondent number 7, Lordship, it is also necessary because the
Who is
then
respondent number 7?
Respondent number 7 is the Lordship Deputy Commissioner who
No,
is
no.
allowed to be impleted in this petition, Lordship. Because the revenue department is very much necessary, Lordship. Because
Let us see their affidavits. Not satisfied.
highly appreciated.
Yes, what is this, Mr. Sharma?
Lordship, sir, Lordship, I'm paying for an accommodation today, Lordship, in this case. The
You
senior standing
come
counsel.
out here for first thing in the morning that asking for accommodation. What is this? What is there
Lordship,
to
the senior standing
accommodate?
counsel will appear in this case, Lordship.
Non-compliance, then violation to the order dated so and so. Arbitrary order, yeah. What is the order you are complaining, Mr. Sharma?
My lord, the impugned order is at page 100. Annexure 17. My lord, what has happened, my lord, is that the contractor, who is the petitioner, my lord, was tasked with carrying out 2 work orders to the effect of 11 crores.
Oh, you go before the civil court.
No, my lord. My lord, I have 2 minute submission, my lord, if your lordship permits.
No. I think this is a fit case for dismissal.
My lord, I'll go to the civil court, provided your lordship agrees with the validity of annexure 17.
Why?
If annexure 17 does not stay.
Challenge that.
No, my lord, the validity and the
No,
legality
no.
of annexure 17, my lord.
You got some money?
I got some money.
You got to go. You have got the petrol.
That dispute is not pertaining to the fact, my lord. This is not dispute on facts, my lord. The dispute has been
The dispute is as regards the rate.
true.
Yes.
And that rate, my lord, is the government entitled, or is the government can change the rate pursuant to a process which has already taken place, my lord.
So,
offer was pertaining to a set of rates. I completed my work pursuant to that rate.
Where's your rate?
My lord, the rates has not been given there.
Then?
No, my lord. That is not the aspect. I have been paid. The part.
No, forget about that. My question is, where was the rate fixed?
My lord,
In your contract,
my lord.
you have submitted bills.
True, my lord.
Then?
No, the bills have been
Civil
admitted.
courts.
My lord will kindly come to page 27.
Civil court.
Page 27, my lord. Page 27.
That day only I was about to dismiss it before when Mr. M.K. Chaudhary was there. But
Page 27, my lord.
yes, what is this? For an amount of so and so invites bid for so and so to be distributed to the people living at periphery for an amount of 11 crores.
That was the entire bid amount.
Ah.
Thereafter, my lord, 2 separate work orders.
Oh, this is a tender value.
The tender value, my lord.
Then
now, my lord.
Where's your bid?
No, my lord will kindly see page 30.
Where's your rate?
My lord, the rates have been mentioned, my lord,
Ah.
in the affidavit which has been filed by the respondent to in the earlier set of the contempt case, my lord, that starts at page 51. Page 51.
Yes, what is the rate? Yes.
Page 51, my lord, will see there's an inquiry which has been
Will first
carried out.
verify the records of the so-and-so blankets supplied by so-and-so under Manas National Park in the month of January and February and cross-check with the actual receipts.
Then the rates are at page 53, my lord. Page 53 of the same inquiry committee report, my lord.
Where?
My lord, the column, the lordship sees the rate.
Observations of the, from the report.
GCI
seen the rates approved against the materials by the then committee in this regard are as follows. So they have put it as blankets, 1310.
Blankets, GCI sheets.
And now what has he done?
Now, my lord, page 100. Page 100, my lord, the last paragraph.
As per the review, the rate of one set of 10,000 should lie in between 1375.
Should lie, my lord.
Should lie between 13,975 to remand. Whereas as per the material, it is found that the contemplator has been paid totally of so and so. What was the rate at which it was paid? The rates approved against 110,000 material, which is 85,000.
My lord.
My goodness. This is flouting government money.
So that is the government on its own, my lord. I was the beneficiary. I was not a part of the decision-making process. They
No,
made a
no,
promise. They
these
made a
we
proposal,
know.
my lord. I carried out the works. And my lord will kindly see, my lord. There are two orders, my lord, that I'd like to point out.
Show me that why the rate is 85,000.
My lord, the
You were issued the contract. Where's your grant of contract? Show us at what rate and what was the materials to be supplied. Show me that.
My lord, may first come to page 657. Page 57, my lord. Page 57.
Where's your work order?
My lord, the work order, my lord, starts at page 28. Page 28, my lord.
Please supply the so-and-so demand to distribute so-and-so, so-and-so, so-and-so at our approved rates directly to the office of the so-and-so. Okay. Where's
Then-
your bill?
My
Submitted
lord,
your
my
bill.
lord.
Where's your bill?
The bill, my lord, there are two bills, my lord.
Ah.
The first bill starts at page 30. And the relevant portion might be for your lordship's perusal at page 31, my lord.
What is the bill? Where are the details of the bill?
The details of the bill, my lord. The first gross value has been given, my lord.
What?
Page
What is
30.
the- how many things you have supplied?
That has not been stated, my lord. Then subsequently, there's another set of bill, my lord, at page 33.
Another 4 crores.
4 crores, my lord. The total
Then?
amount comes to 10 crores.
11 crores.
My lord, deduction of the CGST, GST and the income tax, my lord. at
11
2%.
crores. Comes to 11 crores.
11 crores, my lord. Out
Then?
of that, part payment has been done, my lord.
Uh,
The pending payment is 3 crores 86 lakhs 53,000.
Now tell me one thing.
My lord.
This kindly see this document. What is this document at Annexus 7?
Annexure 7, my lord. Yes, my lord, these are similar work orders, my lord, that we had appended before this honorable court, suggesting
And they have been given 1,25,000.
they have been paid, my lord. 11 crores, my lord. That is the submission that we have made, my lord. Page 30, Annexure 7,
We do one thing.
my lord.
We direct the CID to make an investigation. What do you say? Better off,
Absolutely,
huh?
Lordship, because the rates.
Let the
appear to be
CID
exorbitant, Lordship.
investigate all these things. Why should we look into it and put these guilty people out there? You've got 1 crore. And this so and so and they put them to contract. Anyways, why haven't you filed your affidavit?
Lordship, with regard to that, Lordship, I take responsibility. I had made a submission on a previous date that we would not be filing an affidavit. I had made a submission on a previous date, Lordship, that we would not be filing an affidavit. That was on instruction, Lordship.
Okay.
However, Lordship, after the authorities, they sought legal advice from the senior standing counsel, and if Lordship permits, Lordship will file an affidavit within 10 days.
I don't want. Don't file it. That is your lookout. we take up for final disposal and direct you to make the payment.
Or lordship can
You
fix
cannot,
up any
because
other
you
date,
have,
lordship.
because you are not filing it, you have categorically mentioned this. Last time also I put it. There was another lawyer from BTC who appeared. You have categorically mentioned earlier also.
Lordship, my humble
We
prayer,
file
lordship.
the instant proceedings shall be disappearing. Okay. In fact, I took it up on 29th. Why the matter has come up today? Anyway, list this matter on 23rd of June 2026, on which date an attempt shall be made to dispose
Lordship,
of the
may I pray for
requisition.
25th, lordship?
What?
May I pray for the 25th, 23rd, lordship?
You have nothing to say. What do you have to say on law? There's nothing. The law is very clear. You have categorically given, you have not mentioned, you are not denying on what basis you have arrived at this. You have not, you have on twice occasions, you have said that you are not going to file an affidavit. What is there?
Please, lordship, 25th, lordship, rather than 23rd, lordship.
Why?
On the 25th, lordship, the senior standing counsel will appear in this case, lordship.
Fantastic. We'll have it on 19th then.
19th, lordship.
On
19th, lordship.
Yes.
I have filed my affidavit reply today, but that's not a report. And afternoon.
They want to be impleaded. Who wants to be impleaded? You. Why do you want to be impleaded?
Actually, they are seeking possession and allotment of 3 shop rooms, shop room number 2, 3, and 17. And we are in possession of the said shop rooms.
Okay.
We'd like to file an objection to that, madam, because we file an objection to that application. Because well, that's not true. That's not correct position. The department has nowhere stated that they are in possession. And that's why I would like to file an affidavit on this.
It's okay. Let them, will let us allow them to file affidavits
Right.
after impleading them.
Well, I'm not challenging the implement itself, madam.
Huh?
I want to file an objection to the implement itself, madam. Application
Why?
itself. So they are not, they don't have a right to implement in this case.
Is there any stay order?
No, well, there's no stay order.
Okay. Let them file. You are in possession.
Yes, yes.
Okay.
Yes, let them file.
Mr. M. Dr. Senior Counsel appearing on behalf of the issue notice making it returnable on 14th of September 2026. Mr. So-and-so accepts notice on behalf of the respondent, on behalf of the opposite parties number 1, 2, and 3. Mr. S. Dr. accepts notice on behalf of opposite party number 4, 6, 7. Mr. M. Setia on behalf of respondent number 5. No, we issue notice. Let him take steps by way of raised fee. He's opposing it. Mr. Counsel appearing on behalf of the applicant. Applicants are directed to take steps upon the respondent number 8, performer respondent opposite party number 8 by way of speed post. First, the respondents herein, the opposite parties herein are given liberty to file their objections on or before the name.
May it pleases your lordship. Lordship, I am appearing for the sole respondent here, your lordship. Lordship. Am I audible, your lordship?
Wait. Yes, very much.
Yes, your lordship. Lordship, I am seeking some accommodation, your lordship, today, your lordship. We are yet to file our affidavit in opposition, your lordship.
You are paying for?
For NHIDCL, your lordship. On behalf of Mr. PJ Saikia, Senior Advocate, your lordship.
Yes, madam, why you have, what is
Lordship,
this?
what amongst other things, what we've impugned is a debarment notice debarring the petitioners from participating in any contracts by the National Highway or the Ministry of Road and Transport. This honorable court was pleased to stay the operation of the debarment notice. The stay continues till today. So I'll be praying for an extension. And Lordship, this is the second time they've asked for an accommodation. Lordship may please give them the last opportunity and fix a date
for final disposal. That is my prayer. Lordship, our grounds for challenging the debarment was no notice and debarment cannot be resorted to for simple contractual breach. That's in the teeth of Supreme Court judgments, on the basis of which we got a stay order, and it continues till today.
But madam, tell me how a debarment notice can be stayed as an interim order?
Because your Lordship, may kindly take a look at the debarment clause.
Whatever may be,
Because
you
the
may
Supreme-
set aside, saying that it is bad.
Yes,
There's
your
no
Lordship.
quarrel with that.
Yes, your Lordship.
If it is not in, those judgments of blue dreaming
Yes,
and all
yes, your
these
Lordship.
things are
Blue
not being
then
taken note of,
technoprints. Yes, your
this
Lordship.
court may set aside.
And
But how
we
is the
also
stay
relied
being
on-
granted tomorrow? If this petition is dismissed for default, then what happens?
If it's dismissed for default, Lordship, it will not be, but the.
No, what happens
No,
then?
look at the other side, your Lordship.
Now, if tomorrow the writ petition is dismissed, what happens? During this period, if you are working because of the stay order, what happens?
No, Lordship,
Really, the final order granting a stay.
that is because without notice,
What will happen to a contract which
No.
you have participated? What will happen to a contract which you have participated in pursuant to a stay? And tomorrow, the writ petition is dismissed.
Lordship, therefore, we have established a
therefore,
a strong
normally-
prima facie case. And I can
strongly-
satisfy your Lordship even now again. Lordship,
Whatever strong it may be, but how isn't it amounting to allowing the writ petition
Lordship,
by an interim order without hearing the other side?
and that is allowed, your Lordship, if your Lordship refuses to give us interim stay and it renders our writ petition infructuous. The other side is this.
It can't be infructuous.
It would be. No, Lordship.
Absolutely no. Let us see.
Your Lordship,
Let
give-
us,
give me a
no,
moment.
madam, let us now not extend the interim order for 2 weeks and then see whether it has become
No, Lordship,
infructuous or not.
Lordship, we place before your Lordship dates of contracts.
So let us see whether it will become infructuous or not.
I can give instruction on whether there might be
No,
contracts you're
no, no,
participating
and,
in
you
next
can
2
very
weeks.
well find it out once I am not extending the interim order.
No, then I will come back running to your Lordship to say that we're
Put it there.
participating and we're
therefore
barred
the-
from participating.
So therefore you cannot participate during this period unless you are setting it aside. I don't understand.
No, Lordship.
How can you?
Then Lordship, we
When
keep
I
it
can
tomorrow
ex-
and I'll
I
satisfy
cannot
you
grant
that
an extension.
if you refusal to grant an
We do
interim
one thing.
order.
We do one thing. We finally dispose of the reputation now.
Yes, your Lordship.
Yes. They have not filed the affidavit a long time as well.
Lordship, there are certain grounds, Your Lordship, even we have raised the
Sorry.
question of maintainability, Your
No,
Lordship.
nothing out there.
Lordship, one last opportunity may be granted, Your Lordship. We have
No,
sent it for
nothing there.
vetting.
You cannot do that.
That is
Lordship,
yet
page
to be received, Your
234.
Lordship.
Out there. Where is the notice? What is your ground of?
Lordship, may I just first take you to the debarment clause, page 234 of the contract.
234. Yes.
Lordship,
clause?
It's 5.
As a natural
Roman
cause of
5.
the term
As a natural
due to the contract failure, the contractor shall be deemed to have been debarred for a period of 2 years and shall not be able to beat any contract of the authority either singly or in a joint venture or its related. Authority means without terminating the contract and allowing in the negative list or following units. Now what has happened?
Explanation, Lordship. Such debarment shall be a natural consequence of termination. No separate show cause proceeding shall be initiated for placing such contract under debarment. Lordship, this is in the teeth of a line of Supreme Court judgment which says, please, you can't do debar without
But
a
you
show
have
cause
agreed to
notice.
this term.
Lordship,
You have agreed to this term.
maybe, your Lordship, but if even a term which violates Article 14, your Lordship is, we can come to your jurisdiction and say, sorry, no, it's not amenable to Article 14 and therefore must be struck down.
Let us see the Supreme Court judgment where it says so.
Lordship, Gorkha says you have to give notice.
No, Gorkha, all judgments say that you have to give notice. There's no quarrel with the proposition. But if it is a part of it, then what is?
Yes, your Lordship.
Where does it say?
For that, Lordship, I rely on Blue Dreams and Technoprint to say that for per se contractual breach, a debarment is
No, if
impermissible.
it does blue dreams take into consideration that there is a term out there where you.
Absolutely, Your Lordship. There is
Where?
a term. Yes, Your Lordship. Both blue dreams and are they blue?
Let us see.
Yes, Your Lordship. Blue dreams. Blue dream.
Lordship, here we have issued several notices, Your Lordship. Although the termination notice was only issued recently, there are several notices, including notice for debarment, etc., were issued, Your Lordship, on this matter.
Lordship, blue dreams.
Yes, I've got.
Yes,
the blue
yes.
dreams. I'm
Lordship,
reading.
may
Where is it
turn to
mentioned?
paragraph 22.
No, it's okay. Not
goes
on that.
back.
I'm not. But in the terms of the notice, where a tenderer is declared to be a defaulter, he may not get a contract at all. Say to person because when a person. No, my question is where does blue dreams say that the term of the contract is bad?
Lordship, it says it's impermissible.
Where?
Lordship has paragraph 24, 25, 26.
The significant is the improvement of the government.
Taking the term of the contract as well. Taking the-
No, this is not the case. So therefore, when you have a term in the contract.
Then Lordship may come into techno. Techno is clearly a term in the contract.
Where? Yes.
Lordship, blue dreams categorically says for an ordinary breach where there's a bona fide dispute, it's impossible to
No.
pursue debarment.
Blue dreams does not deal with a question when you have a term in the contract.
That's right.
So let us see techno.
Yes,
Where does
techno. Paragraph 5 reads out the clauses 16.9. Lordship has 16.9 in the second page. Right at the bottom. If the tenderer is awarded to the lowest rate printer on the basis of L1 rate of groups and Nigam allots the printing works to the tenderers on the basis of L1 rate of groups, then also if tenderer refuses to do printing work or work not completed, in this condition, Nigam has the right to put the tenderer in blacklist for 3 years security and deposit, EMD, etc. So this is the term of the contract.
What does it say about clause 16.9?
Yes, Your Lordship. Paragraph 24. Page 22 up. Paragraph 24, may I read? Then it cites 25 is Khulja. Then it cites blue dreams, which is the principle that's laid down. Lordship, paragraph 32 is when it says you come to 226. And 33 is when it says power cannot be resorted to for violation of a term. And 34. Lordship, paragraph 32 when it says you come to 226, Lordship has that. And 33 is important. The last
Lordship.
5 lines, 1, 2, 3.
With sincere apologies, Your Lordship, Lordship, if Your Lordship allows us to file our affidavit, Your Lordship, factually, we could highlight certain letters that we have already issued, Your Lordship, prior to the termination and debarment, Your Lordship.
The power to blacklist cannot be resorted to when grounds are for the same are only breach of a violation of a term or condition of a particular contract, and when legal redress is available to both parties. For else,
So-called notice was interfered.
yes, set aside.
Was else. But
Yes,
the court did not go into the question of clause 16.9 to be banned.
But they relied on 16.9 for the show cause.
16.9 says that if you are the lowest bidder, you are to complete the work. And therefore, they will go for it. Supreme Court says that, look here, they could not have done so, taking into account that there was a bona fide dispute.
Correct.
And this
Yes, I'm relying on
it is
that law.
not the case where they have initiated without a show cause notice.
Lordship,
they
here
proceeded.
we're worse off. At least there was a show cause notice. Here
Understood,
it
but-
violates
but-
this and Gorkha
But a
because there's
court
no
did
show
not
cause.
go into the clause 16.9, the legal validity.
No, but they have to the extent,
No, I read the
probably
letter.
not directly, but no, Lordship.
I can't extend the interim order. Very difficult. We
Lordship,
have not
one-
filed the affidavit after 5 months, 3 months.
Lordship, it is already sent for vetting, Your Lordship. We have not received it back, Your Lordship.
Waiting for a long time.
My sincere apologies, Your Lordship. We are awaiting, Your Lordship, that will be provided shortly, Your Lordship.
Lordship, we got an interim order on the ground that because of this debarment, we listed 9 contracts which we could not have participated in.
So what?
Lordship, in which case then the debarment is punitive and it's a civil death in reality.
Now, all understood, madam. but
So,
the
so
question-
Lordship, what,
question remains that
Lordship,
how-
test it, Your Lordship.
How the
The
question-
Supreme Court says, forget natural justice. On the face of natural justice, the debarment should have gone. So I have established prima facie, you have not even given me notice. Gorkha says that's good enough. You don't give me notice, the debarment goes. I established that on day 1.
But Gorkha
I am
was-
on
Madam,
a
Gorkha was not a case wherein you had a clause to that effect. And
Lordship,
in Techno, they have not taken into consideration
Lordship,
the
a
legality of
clause in the
69.
contract doesn't make it better, and that is
Oh,
what,
obviously.
that is what no,
This is the
no, that
penalty.
is Lordship, that is why Techno is important. That is why Techno is important, and all those paragraphs which analyzes is important, which says that for a mere alleged contractual breach, you can't go to debarment because why? Debarment is something more than just a penalty. It's a civil death. It's not a damage for termination of a contract. It in the end kills your business. It may be for 2 weeks, it may be for 2 years. But for that period of time, your company is rendered dead. Which is why Justice Pardiwala says, just on the basis of that, Justice Pardiwala and Justice Viswanathan, both, the analysis is the same. The analysis is not about a clause in the contract. Your Lordship is correct. Because clause in the contract is easier. The analysis is that forget contract, forget inherit. Blacklisting is a civil death. And if you want to impose blacklisting, it has to be more. And it says, it can't be a contractual breach. it must be what very nicely put in techno. It must be a conduct that is abhorrent. And that is what it is. Here it is undisputed, just a contract. The clause says it. I could not perform my contract and therefore I blacklist. That clause, in my humble submission and with respect, is in the
You
teeth
will not
of
challenge the clause.
Lordship. I do not have to.
But then,
I'm relying on Supreme Court to say you can't go to that, and the Supreme Court has held so.
where has the Supreme Court held to? My question is there.
The Supreme Court has set aside that
No,
debarment.
irrespective of the clause being agreed
Irrespective-
upon.
I'm obliged. Irrespective of a clause in the contract, they have set aside. Your Lordship, I'm
No,
obliged.
The Supreme Court says in Techno that there was no case for issuance of a show cause.
Lordship, at least there was a show cause. Lordship may then read. May I read paragraph 33? Maybe I've got it wrong. Paragraph 33.
Yes.
An order blacklisting casts a slur on the party being blacklisted and is stigmatic. That is the premise. Given the nature of such an order and the import thereof, it would be unreasonable and arbitrary to visit every contractor who's in breach of his contractual obligation with such consequences. There has to be strong, independent, and overwhelming material to resort to this power, even given the drastic consequences that an order of blacklisting has on a contractor. The power to blacklist cannot be resorted to when grounds for the same are only breach or violation of a term or condition of a particular contract, and when the legal redress is available to both parties. Else, for every breach or violation, though there are legal modes of redress and which compensate the parties like the corporation before us, it would resort to blacklisting and at times by abandoning and scuttling the pending legal proceedings. Plainly, if a contractor is visited with punitive measures of blacklisting on account of an allegation that he has committed a breach of contract, which is a case, the nature of his conduct must be so deviant and aberrant.
Reads that this court had passed an interim order had issued notice on 18/2/2026 and had stayed the impugned debarment notice dated 3/2/2026. In spite of the interim order, the respondents have not cared to file any affidavit in opposition. For the last 3.5 months, considering the above, list this matter tomorrow at 2 p.m. for final disposal. Interim order passed earlier shall continue till the next date.
Lordship, may I pray that the matter may be taken up next
Absolutely
week, Your
no.
Lordship?
I'm allowing the petition tomorrow.
Oblige, Your Lordship.
I don't have the time.
Last opportunity, Your Lordship.
Absolutely no. Sorry. This type of matters I don't allow. I will give you the liberty to issue a notice and proceed. You may do so, but I'm going to set aside this on the ground that mainly on the basis of the clause you cannot.
Lordship, there are certain grounds, Your Lordship, in this matter.
What do you
Like
mean grounds?
unlike
You have not
how
come up before this court. I can't help you. You have not filed your affidavit. It is not so. It's
Lordship, I'm sorry, Your Lordship. It is already sent, Your Lordship. We may be allowed, Your Lordship, to bring that on record, Your Lordship.
Go before the division bench after I pass the order tomorrow.
Lordship, some other day, Your Lordship. Kindly, Your
Tomorrow at 2
Lordship.
o'clock. Today I don't have the time. 5 o'clock we have a full court meeting. Otherwise I would have disposed it just now.
Lordship,
Yes.
there were several irregularity.
Tomorrow. Yes, what is this?
And this is a petition for non-payment of contractual dues by Department of Disaster Revenue and Disaster.
Denial?
Lordship, we already been file our affidavit.
What do they say?
Today, Lordship. Under the paragraph number 6, we have to.
No comments so far.
Or paragraph 5, my lord. Sorry, paragraph number 5, Lordship. I'm sorry. 11 portion. Page 30.
What is this if otherwise entitled? whether he's entitled or not. That is the only thing we are required to do.
We are going to verification, my lord, regarding the examination and verification of the, my lord.
Okay, verify and pay in 6 months.
After
6 months, within 6 months. Yes, Mr. Goswami, your matter?
It's all a tender matter, very peculiar. Because the clause was that if you are successful, you have to pay, you should provide a bank guarantee, plus also a security within a time that is fixed under the contract. In our case, it was 13/1/26. We had to give a bank guarantee of 77 lakhs, 70 lakhs 50,000. And security 11 lakhs. We are not concerned with security. We are concerned only with the bank guarantee. We, Milot, on 13/1, we have done our part. The bank, there was a problem in their digital thing. Kindly turn to page 130. Your lordship will get the thing. It is because of a
Mr.
default.
Goswami,
Yes.
let us do one thing.
Yes.
As there is an interim order, you are enjoying it. You have filed an affidavit.
Yes.
Mr. Singh, you have filed affidavit.
Yes, we have filed our affidavit in opposition, my lord.
Would you like to file a reply? You have filed your reply. The reply is not there. Anyways, is there any urgency in the matter?
Only urgency
My lord,
is,
only,
Yes.
because our money is
Stuck.
already there.
There has been put in an interest bearing here.
Yes.
yes, my lord, in the fixed deposit, my lord, as directed by this honorable court, my lord.
If they give
So,
us,
my lord,
Can we
can
take
it be
it
taken
up
up on 11?
18th of
18, my lord. My
18th
lord.
of 18th of June?
June. My lord.
We'll take it as a first item. Yes.
Yes, my lord.
List this matter on 18th of June 2026 at the top of the list for final disposal, taking into account that there is an interim order. The interim order passed earlier shall continue till the next date.
Obliged, my lord.
Put it aside. Close for